Tractate Gittin discusses the laws of divorce, and particularly the divorce document, the get, which is given from husband to wife at the time that he wants to end their marriage. The exact method of giving this document, how it must be written, and the witnesses that must view this transfer will all be described throughout. Chapter 1 begins the discussion of these laws. The first Mishnah says, if an agent brings a divorce document to Israel from abroad, he must declare that it was written in his presence and signed in his presence. Rabbi Gamliel says this must also be done if it was brought from the towns of Rechem and Cheger. Rabbi Eliezer says this must even be done if it's brought from Kfar Ludim to Lud. But the rabbis say it must only be said if it's being brought to or from abroad. It must also be said by the agent that it was written and signed in his presence if he's bringing it between two different provinces abroad, while Rabbi Shimon ben Gamliel says even between two specific jurisdictions. In regards to the definitions of the borders of Israel, anything east of and including Rechem is considered abroad, anything south of and including Ashkelon is abroad, and anything north of Akko is considered abroad, and it's debated if Akko is considered a part of Israel by these laws. If somebody brings a divorce document within Israel, he's not required to clarify that it was written and signed in his presence, and if people debate the validity of the document, it should be confirmed by the signers of the document. The Gemara explains there are two reasons why such a declaration would be necessary. Either because people abroad don't really know these laws so well, so we're clarifying that the agent must be able to say that the document was written and signed properly with the correct intent. Secondly, it's done because it's difficult to get witnesses in such a situation to confirm the document signatures, so we simply have the agent confirm that he saw it signed when he delivers it. There's a practical difference between these explanations. Either if two agents are delivering the document, the second explanation wouldn't require them to make this declaration. If the document was delivered between provinces within Israel, the first explanation would not require the declaration, and if it was delivered within the same province abroad, the second explanation wouldn't require the declaration. According to the first explanation, that the people abroad don't really know these laws so well, it debates how a single witness is sufficient to testify that the document was written properly, so rather it's explained that those abroad do actually know how to properly write the divorce document, or at least their court scribes know how to. The reason one witness is permitted here is as a leniency to prevent the woman from having to remain in stasis, not with her husband, but also undivorced, unable to remarry. So we want to make it easier for her to be able to get this document. When she receives it, she'll do so before several witnesses, so the husband won't be able to later challenge the document's validity, and also the agent will be careful to make sure that everything is valid himself. In accordance with the second explanation, that the witness's declaration is necessary as it's difficult to get witnesses to confirm the signatures, the reason one witness is allowed is also debated, and the reason is given that the signatures on the document are considered as if they were examined by the court and accepted, and the single witness can confirm it for the same reason as before, because we want to make it easier for the woman to receive her document and just not be stuck without a divorce. It's explained why the second opinion disagrees with the first one, who says he must confirm the document was written with correct intents. He says he disagrees as the requirements of the declaration warrant to say that he saw it written with the correct intent. He just needs to say he saw it written. The answer to this would be that they didn't make it too long, as otherwise the agent might not say the whole quote and it'll then be ineffective. The first explanation debates the second, that it's done as it's difficult to testify the signatures of the document, as then he should only really need to testify that he saw it signed, not that he also saw it written. The answer to that would be that they have to clarify that also, so that we don't think this is permitted by other cases of document confirmation to confirm it with one witness. Based on these explanations, it debates who the author of the Mishnah was in accordance with the opinions held by these laws, if they line up with the cited opinions by the Mishnah. In regards to the cities of Rechem and Cheger, those are explained to be border towns of Israel, and Kfar Ludim is said to be surrounded by the border, like this. Seemingly, the dispute from the Mishnah in regards to the permissibility of documents from these towns is the same dispute as to whether they're not quite far enough abroad that they won't know how to make this document so they would be permitted, or that the witnesses on the signatures are too far so they won't be allowed. The same debate as described here. Alternatively, this dispute can be interpreted entirely like both opinions. If the issue is of improper intent from an abroad divorce document, you can say that the border towns may not be so knowledgeable, or surrounding towns must do it so that way they'll be like all the other abroad towns. The other opinion would apply by this too, only the issue would be he'd hold that border towns are actually too far away to go and get a signature confirmed. We bring similar instances of such a debate and challenge these opinions from particular instances that imply like the other. There are a few additional various cases brought which imply like the other opinion to try and disprove the other, but they're individually qualified to work like both. It's even brought that actually both opinions would agree that in actuality a declaration is needed to confirm the signatures. It also cites which other opinions hold like these two explanations and as to whether they require the additional agent to come with this messenger to certify the validity of the document. Some would even say that if somebody deviates at all from the established procedure of giving a divorce document, the divorce is unsuccessful, meaning if she remarries, they must divorce and their children are illegitimate, as seen in a different case. It also said by the witness watching the writing of the document, he only needs to watch one line be written, as if we started being more stringent, that would cast doubts on many prior written and certified divorce documents. Some even say it's sufficient for the agent to have just heard the sound of the quill writing on the parchment. This would apply even if the scribe was going in and out of the house, and there's no concern that somebody else asked him to write a divorce document for the wife with the same name as the one the agent was certifying, meaning the scribe would now have written it for a different woman, which is not allowed. So that's said to not be a cause for concern. There's a debate if Babylonia is considered to be a part of Israel by these laws of sending an agent to deliver a divorce document. The debate in question is as there were schools all over Babylonia, so they'll be able to certify the signatures with witnesses, while others hold that the students will be busy and unable to certify them. Further, when the Mishnah said everywhere north of Akko is considered like outside of Israel by these laws, that's everywhere excluding Babylonia. By these laws, the border of Babylonia is said to extend until the second willow swamp past the bridge. There are other cities mentioned. It said that when delivering a divorce document, they must make the declaration when going from Aktisphon to Bay Ardashir, but not vice versa, as there were markets in Aktisphon that people traveled to, so the merchants recognized the signatures, but the shop goers would not. There was this one city, Mechuzah, whose people were always traveling, so their witnesses were required to make a declaration even within the same neighborhood. The declaration is effective to invalidate a husband's challenge, even if the declaration wasn't really necessary in its case. It's also said that a declaration isn't necessary if the document is being brought from Babylon to Israel, as people to certify the signatures will be found, as people frequently traveled between Babylonia and Israel. It expounds on some related verses, and it speaks on the importance of not having excessive fear in a person's household, as that'll lead to many negative consequences. There's further discussion on this point and on the virtues of being silent in the face of enemies and simply praying to God or learning Torah or similar, which will have God answer instead. It also speaks on the prohibition for bridegrooms to wear a wedding crown after the destruction of the temple, although some hold it was only prohibited for men to wear. It also speaks on the importance of giving charity. It debates the exact placement of the city of Akko in regards to these laws. It's also debated if a divorce document written on a boat in a river is considered to be like in Israel, as to whether the rivers are considered to be like Israel. This is debated from discussion of other laws. If we debate the definition of the borders of Israel and how this extends over the Mediterranean Sea. It also explains how the land of Syria is similar and different to Israel in various ways by multiple laws, as it was conquered by King David. These laws are discussed further. It gets into a related point on if a slave brings his emancipation document from abroad and it says, "Your person and my possessions are acquired by you." The slave goes free, but he does not acquire the possessions. If the document just wrote, "All my possessions are acquired by you," it's debated if this is valid. Some say no, as it's a single statement, so he doesn't get his freedom or the possessions. Others say yes, as it's like a divorce document that the woman herself can confirm and free themselves, but not get any extra possessions. The points are further disputed. The ending of the Mishnah was that if people contest the divorce document, it should be confirmed through its signers. The disputant in question would refer to the husband. New Mishnah. If somebody brings a divorce document from abroad to Israel and cannot declare that it was written and signed in his presence, if there are witnesses who signed it, the signers must confirm it. These laws of divorce documents and slave emancipation documents are similar by taking the document to and from Israel, among other laws. The Gemara explains the case in question, where he cannot declare that it was written and signed in his presence, is where he saw it written and signed properly, but then he later became a deaf mute. It lists other similarities between a divorce document and a slave emancipation document. These similarities are further discussed. There are additional points. New Mishnah. Any document with the signature of a Kuthian witness is invalid, besides for a divorce document and a slave emancipation document. It cites an incident where this occurred. The Gemara debates the author of this Mishnah as to who holds like these laws in regards to the Kuthians. And it says the case is like the opinion that doesn't typically allow Kuthian signatures, but here there's a signature from a valid witness underneath, so everything's certified. This case is further debated. New Mishnah. All documents processed by non-Jewish courts, even if the witnesses who signed them are non-Jewish, are still valid documents besides for divorce or slave emancipation documents. Some say even those are still valid, they're just invalid if it was made by somebody who's not a judge in such a case. The Gemara asks, based on this, why a gift document signed by a non-Jewish court is still valid, and explains, as has been established, that the law of whatever country you're in is legally binding according to Jewish law also, so they would still hold validity. The opinion that it does allow such divorce documents is where the signatures all have clearly non-Jewish names, but if they aren't typically non-Jewish names, then that's where they would be treated like private documents. Alternatively, is that the ending part is just in regards to financial documents, which are only invalid if written privately. It brings sources for this view, and it brings instances of the validity of other such documents. This is discussed further. New Mishnah. If somebody tells their agent to give a divorce document to their wife or to give an emancipation document to their slave, according to Rabbi Meir, if he wants to retract this before it reaches them, he can. The rabbis say he can only do it for the divorce document, as they hold you can only benefit a person in their absence, not disadvantage them. Here, a slave's support is voluntary, while a wife's support is mandatory. Rabbi Meir argues that by emancipation of the slave, he can no longer eat teruma, so it should be disadvantageous to him also, but the rabbis say the slave is his property, so it's not really their loss. The Gemara says, based on this, according to the rabbis, if somebody takes property from a debtor on behalf of a creditor, the creditor can viably acquire it as it was only advantageous to him. Others disagree with this point, and it's debated. It argues these opinions based on several related verses and topics. If further debates based on this discussion in the event that somebody owned a slave, whether he's legally required to sustain him, and as to the point that he cannot take his earnings without feeding him, and similar. This topic is further debated. There's additional debate as to whether somebody can make their slave work without being obligated to feed them. Many bring proofs from several discussions that this is not permissible. Others disagree. There are additional points on this. New Mishnah. If somebody tells his agent to give a divorce document to his wife or an emancipation document to his slave, this is no longer done if the husband died in the meanwhile. If the husband told the agent to give somebody an amount of money and then died in the meanwhile, the agent would still deliver the money. The Gemara says the money case is specifically where the husband pointed to the actual physical coins he wanted given, and some say the husband in question is healthy and he gave the coins in the presence of the agent and the recipient to automatically transfer it to them. Others say it's a sick man giving the coins and he's allowed to send an agent to give specifically specified coins, out of concern that if it was unspecified, he may have been referring to some hidden coins somewhere. Although it is ruled that that's not a concern. These two answers disagree with each other, as the second doesn't hold with the principle of automatic acquisition between all three parties, whether it's a loan or a deposit, and the first opinion disagrees with the second, as they hold that the wording of the Mishnah implies that the case uniquely cannot be referring to a sick individual based on the sending of the divorce document portion. These opinions further debate this. Some clarify that the principle of the three present party acquisition was tradition passed down from Mount Sinai, among a few listed others. It brings some instances and examples of this principle's occurrence. It's additionally debated as to whether somebody in debt who gives money to an agent to be given to the creditor, whether or not he's allowed to retract that payment prior to it reaching the creditor, meaning it's questioned if it's been fully acquired on behalf of the creditor or not. They cite sources in accordance with their opinions along with a few related incidents. The point on whether telling an agent to take something is considered an acquisition, if that's the case, is debated further based on other sources. There's additional points on this in regards to a particular case. And that's the end of chapter 1. Chapter 2 of Tractate Gittin continues going through the laws of divorce and the divorce document. The first Mishnah says, if somebody brings a divorce document to Israel from abroad, and he only said the document was written in his presence, or he only said that the document was signed in his presence, or he said that it was written in his presence and half was signed in his presence, or he said that it was signed in his presence and half was written in his presence, in all those cases the document is invalid. If one person says it was written in his presence and a different person says it was signed in his presence, it's invalid. If two people say it was written in their presence and one person says it was signed in his presence, it's debated if this is valid. If one person says it was written in his presence and two people say it was signed in their presence, it's a valid divorce document. The Gemara says this is necessary in addition to the first Mishnah of the tractate to show that the document is valid specifically if the agent says he saw it written and signed in his presence. In regards to the agent seeing half the document written, it refers to the last half. If somebody saw the document written and half of it signed, we said it's invalid. Some say even if there are two additional people who come and certify the signatures, the document is still invalid as the document can only be confirmed through the standard signature confirmation, or through the instituted agent confirmation, and not through a combination of both. Others disagree with this and say it'd only be impermissible if there was one other person certifying the signature, as we don't want people to draw a false comparison that one witness is sufficient by other monetary document certification. Others say that this would still be invalid for the above stated reason that it can't be a combination of certification methods. This argument is further disputed from additional sources, and it brings other similar arguments as to the validity of combining different factors to create a single status, like by different wall measurements, different combining hand washings, and similar, which are all disputed points. These laws are debated, and there's some unresolved questions about the validity of immersing half of somebody in a mikveh and then pouring water on their other half. It was held that if one person says the document was written in their presence and another person says the document was signed in their presence, it's invalid, but it said it would be valid if both of these individuals were appointed as agents to deliver the document. There are other versions of this dispute which are additionally qualified. It was said, if one person says the document was written in his presence and another two say it was signed in their presence, it's valid. This is said to apply if the document was produced by the witnesses to the writing, as that individual has additional credibility, so it's as if two of each certify the document. This would imply that if two agents bring the divorce document from abroad, they'd still need to certify that it was written and signed in their presence. Others debate this point, and it's discussed. New Mishnah. If a divorce document was written and signed on the same day, or written and signed on the same night, or written at night and signed on the following day, it's valid. If it was written by day and signed that night, it's debated if it's valid, some permitting a predated divorce document only as opposed to other types of documents. The Gemara gives explanation as to why a divorce document must have a date recorded on it. Some say that if the woman in question was married to her uncle and then committed adultery, the husband would want to protect her, so would predate a divorce document to make it look like they had gotten divorced beforehand. Others say it's to prevent a husband from benefiting off of his ex-wife's property after the divorce. The reason the second explanation disagrees with the first is that they hold that unchastity is uncommon, and the first explanation disagrees with the second, as he holds that the husband can use his wife's property up until the time of the actual giving of the divorce document. Accordingly, these opinions would dispute in accordance with the opinions from the Mishnah as to whether a predated divorce document is actually permitted, as the second explanation's issue doesn't really involve predated divorce document, it's more involving post-dated ones. This means they'd all hold differently as to when the husband can't benefit from his wife's produce property, either from when the divorce document is given or written, depending on the Mishnah's dispute according to explanation 1, or from when it's signed or written, depending on the Mishnah's dispute according to explanation 2. There are additional points on this. It says, we're not really concerned about the husband cutting the date part out of the document to steal his wife's produce. We say, if on the document the date is written as just the 7-year sabbatical year cycle, or just the year, or just the month, or just the week, it said the document is still valid as it prevents the husband or wife from doing any of the listed wrongdoings within that time frame. It also says that's not really a concern of a case wherein a husband writes a divorce document and then hold on to it just in case, as it said a person really doesn't do that because he doesn't want to bring misfortune upon himself in such a situation. Additionally, there's not really a worry of predating in a divorce document brought in from abroad and it taking a very long time to reach Israel to be given, as people would hear about it and then report the timings. A woman typically needs to wait around 3 months before remarrying to prevent issues of pregnancies from being possibly from either husband. There's a debate if we start counting this period from the time of the giving or the time of the writing of the divorce documents. These opinions debate this and cite sources for their respective opinions. The law, however, is that it's decided to be that the counting starts from the time of the writing of the document. There's a similar dispute between these opinions as to when a marriage contract becomes considered like a normal debt contract, which can get cancelled by the sabbatical year. Some say when the wife accepts partial payment from the contract and establishes the balance on her ex-husband as a loan. The opinion says only the first part is necessary. They cite sources, but we find one that implies more like the second opinion. There's additional argument if a marriage contract can be predated, like other documents, which is argued between these opinions. The opinion which permits a predated divorce document would hold that once the husband decides to divorce his wife, he can no longer eat the produce of her property. Additionally, he'd only permit this predated divorce document if it was written and signed immediately. If it was signed from then until 10 days after, it would be invalid, as there's a concern the couple would reconcile and then cohabit, thereby invalidating the document. Others disagree, saying if such a thing occurred, it would then be public knowledge. There is a case brought if a man went to 10 men and told all of them to write and sign a divorce document. Some say this means that 2 of them are acting as witnesses and the remaining are just as a stipulation on the document. Others say that all 10 must act as witnesses. There's a practical difference if 2 of the 10 men sign it on that day and the remaining men sign it on later days. The first opinion would hold that this is valid, and the second would say this is not valid as they were all witnesses. Another difference would be if one of the 10 was a relative. If one of the first two men that signed were ineligible or a relative, some say it's valid as he's just fulfilling the stipulation. Others say it's invalid as it could get confused with a case of regular documentation. A case like this did occur with only two signers doing so on the day of, and it was ruled leniently by an emergency. This is qualified. New Mishnah. A divorce document can be written with anything, with ink, paint, red pigment, copper sulfate, or anything lasting. You can't use liquids, fruit juice, or anything impermanent. A divorce document can be written on anything, on a detached olive tree leaf, on a cow's horn, although the husband must give the woman the cow, on the hand of a slave, but he must give the slave, and others hold that you actually can't write a divorce document on the hand of a living creature or food. The Gemara further defines all of these different types of pigments. Some Shabbos laws, by types of ink, writing is forbidden on Shabbos, and it's said that if somebody traces over black ink on Shabbos with red ink, he's liable for both writing and erasing. If he traced black ink over black ink or red ink over red ink, he's not liable. If he traced red ink over with black ink, some say he's liable only for erasing, others say he's not even liable for erasing, as he destroyed the letters beneath. This is a stricter opinion by Shabbos laws. For instance, this opinion would say, in spite of this logic, by a divorce document, you can't have somebody write the signer's name in red ink and have the signer himself trace it over in black ink. For an illiterate signer, some suggest etching their name into black paper and having them fill it in with black ink. Others say we can write their name in lead and then have them trace over it with ink. This is assuming the lead isn't water steeped in lead, which actually can be used to write the document itself. Some suggest having them trace over their name writing in gallnut juice, assuming the paper was pre-treated with gallnut juice so that way it won't show. Some say they should trace over their names written in saliva. All of these methods work only with divorce documents, not with other variants. Sources are brought and it debates the necessity of the witnesses actually reading the document. If the document was written in a foreign language, some would have people who spoke that language read it to them separately, informally, and use their translation to facilitate the document. Some say if the document was written in a foreign language but Jewish witnesses signed it, it's nevertheless still valid, although this is debated in regards to the assurances necessary that it's not a forgery. If a husband gave his wife a blank document and said it was the divorce document, some say this is valid, as it could have been written with gallnut juice, which got absorbed into the paper, although they clarified that at the time of the giving, it wasn't fully absorbed, therefore making her a doubtful divorcee. This is qualified, and it brings additional cases of unique divorce document deliveries. If the husband says, "This is your divorce document," and then throws it between some jars, and the woman goes to find it and instead finds a mezuzah scroll, assuming it's the only of such scrolls found, we assume that's the document the husband threw, as mezuzah scrolls aren't typically left among jugs. There's a case mentioned where a husband took a Torah scroll and gave it to his wife, saying it was her divorce document, and it's explained this is invalid as the Torah scroll was treated with gallnut juice, so the new writing wouldn't show against it. In the event that the person writing the document didn't do so with the intent that it should be for the woman, so then retraced over everything with the proper intent, it's debated if this is allowed based on a dispute, if it's allowed to retrace over such a document. There are additional points on all of this, along with points as to whether engraving is a permissible manner of writing a divorce document, which is debated based on the definition on the manner of engraving and indentation. There's additional lengthy discussion on all of these points. It also goes through some further unique manners of document transfer, including a case where a husband gives his slave a divorce document for his wife and then gives his wife a gift document for the slave, thus allowing her to acquire the slave and be divorced through the document that he's holding. This would function validly so long as the slave is bound, therefore giving him a similar legal status to a courtyard, which a woman is allowed to acquire a divorce document from. Both of these points are specified to show that either the bound slave or the courtyard individually function to allow transfer of a divorce document through them. Others dispute this, saying the woman needs to be actually handed the document, meaning an acquisition with her consent, but this is refuted. In regards to writing the document on the horn of a cow, it said you must give the cow, as severing the horn after the writing would intervene between that and the giving and invalidate the document. It gives sources for the opinions which hold the divorce documents cannot be written on living creatures or food, based on verses, although the other opinions interpret them differently. New Mishnah. It's an invalid divorce document if it's written on something attached to the ground, although if it's written and then detached and then completed and then given to the woman, it is valid. Others say the writing and completion must be both done after it's detached. Some hold we don't write a divorce document on previously erased paper or on unfinished parchment, as that could be forged, but others disagree. The Gemara explains the divorce document that would, in theory, be valid if attached to the ground, that's if the entire first portion of the document containing the names and are all not yet filled in and will be written only after it's detached. Some say this portion, that's the part that can't be written while it's attached to the ground. Others say it's the signatures that are the main concern. It's agreed that if a person wrote the document on an earthenware perforated pot, it's valid, as he could give the pot. If you wrote it on a leaf in such a pot, it's debated if this is valid. Some say it's allowed, as, again, he could just give the entire pot. Others say no, as this is concerned, he'll pull off the leaf and give it to her, which would not be allowed. It brings some additional laws of acquisition in regards to the perforated pot, as to if the acquirer also gets the seeds, and similar, along with some laws on tithing, which are discussed further. In regards to not writing the divorce document on unfinished parchment, it gives definition as to the different levels of high treatment, which has practical differences in regards to the minimum amount of liability for carrying by the laws of Shabbos. In regards to the opinion that you can write the divorce document on erased paper or unfinished parchment, this is as he holds that it's the witnesses of the document's delivery who have the power to sever the marriage, and there's debate if there's still concern for forgery as to whether such a document must be used immediately or not. It's also disputed if this leniency applies only to divorce documents, according to this opinion. New Mishnah. Everybody is qualified to write a divorce document, including a deaf mute, an insane person, and a minor. A woman can write her own divorce document, and a man can write his own receipt for a marriage contract payment, as their validation is through the signers of the documents. The Gemara says, some hold by those first three, who are legally considered mentally incompetent. It only works if an adult stands over them and instructs them. This would not apply by an idol worshipper who's writing this document, as he has his own logic and intents. This opinion is disputed. Some even say if a divorce document is found just lying in a pile of garbage, it can be used so long as the wording and names all line up, and if it hasn't been signed yet. There are further such points, and it's a dispute as to whether just the signing or even the actual writing of the text of the document needs to be done with the correct intentions for all of these cases. Some interpret our Mishnah, where the mentally incompetent individuals write the document, to be specifically referring to where they left the first half of the document blank, which is disputed based on if you hold it's necessary. New Mishnah. Everybody is qualified to deliver the divorce document to the wife, besides for a deaf mute, an insane person, a minor, a blind person, and a non-Jewish person. If the minor received the document and then became of age, or the deaf mute received it and was cured, or similar with all of the other examples, he's still not allowed to deliver the document. If a regular person was given the document and then became a deaf mute or insane or blind or similar, and then was healed and went back to normal, he can bring the document. As a general rule, if somebody is mentally competent at the beginning and end, he's qualified to bring the document. The Gemara explains why a non-Jewish person can't deliver the marriage contract. He is considered to be mentally competent, it's just that the laws of marriage by him are different than by a Jewish person, so he can't legally bring a divorce document on somebody's behalf. The issue with the blind person bringing it is debated. Some say it's because he doesn't know who he's giving it to. Others say he could use voice recognition, so the issue is that the document is that it's being brought from abroad, meaning the agent must testify that it was written and signed in his presence, which a blind person cannot do. And people clarify that it would be valid if he wasn't blind and he saw it signed and sealed, even if he's still blind when he brings the actual document, unlike by all the other cases. It disputes if a Canaanite slave can bring such a document based on a similar logic as to why a non-Jewish person can't bring it, and that these laws don't apply to them. Some say it does to an extent, so it's disputed. New Mishnah. Women who are not believed to testify that a wife's husband died, as described towards the end of Tractate Gittin, being a mother-in-law, a mother-in-law's daughter, a co-wife, her husband's brother's wife, and her husband's stepdaughter, are nevertheless still trusted to bring the divorce document, as there is a written document which proves legitimacy here. The wife herself can bring the document, but must testify that it was written and signed in her presence. The Gemara brings a source which seems to say that these women are not actually trusted to bring the divorce document. Some say the difference is if this occurred inside or outside of Israel. It's disputed which way. There are disputes for it not being allowed if it was written inside of Israel. This is further discussed, and it goes through how a wife can bring her own divorce document. Some say it's as the husband tells the wife to be an agent until she arrives to the court in Israel, at which point she should give it to a second agent who she would receive it from. Others say she should testify to the court that it was written and signed in her presence, and then the court should give it to a second agent who then gives her the document. And that's the end of Chapter 2. Chapter 3 of Tractate Gittin continues going through the different laws of divorce and on the writing and delivery of the divorce document. The first Mishnah says, a divorce document that's written for the sake of a different woman is invalid. For instance, if a man was walking through the marketplace and heard a scribe writing a divorce document specifying coincidentally him and his wife's name, he can't use that document. Or if a man wrote a divorce document for his wife and he then changed his mind, somebody else with the same name and wife's name cannot use that divorce document. Or if a man had two wives with the same names and he wrote a divorce document for one, he can't go and use it for the other wife. Or if a man told a scribe to write a divorce document for one of his two wives that had the same name and he decided which one to give it to, that's invalid. The Gemara explains the first case, based on particular use of wording, is where student scribes were practicing writing the divorce document. This means that the document wasn't even a divorce document at all, and the second case is more extreme as it was an actual divorce document, and the third case is more extreme as it was written for the man to divorce with, and the fourth is more extreme as it was technically also written to divorce the correct wife with. It cites scriptural sources for the disallowance of all these cases, that it must be a valid divorce document written specifically for the correct women alone with no retroactive clarification to make it for the women. In the third case, where it was written for one woman and he wants to switch it, he is still allowed to use it on the first original woman. Based on this, some derive that if two people with the same name who live in the same town, they both may produce a loan document against each other. This is debated. In spite of the lack of validity to the above cases of unspecified divorce documents, they still do work to make it that the woman can no longer marry a Cohen, although it's a debate if the first case works in spite of its invalidity. Some say only the last case disqualifies her from marrying a Cohen, some say none of them do, and there are related points on these opinions. According to this, it further asks if retroactive clarification would function in regards to the writing of this divorce document. Some say no, and it's questioned based on a discussion by the bringing of the Paschal offering being retroactively clarified to be for one of somebody's sons, as discussed in Tractate Pesachim, depending on who gets there first, although that's said to not be really the principle of retroactive clarification so much as it is a father encouraging his sons to run and do a mitzvah. This was all discussed on page 89a of Tractate Pesachim. In regards to the validity of retroactive clarification, berera, as it's called, by the divorce document, it also debates if this only applies if the decision being made, which the clarification hinges on, is being made by the individual himself or somebody else. It brings some instances to try and prove that seemingly many hold that retroactive clarification does not function if you yourself make the decision, but they would hold its permissibility if others are making the decision. Others debate this and still accept the validity of retroactive clarification if it's made by others or himself. New Mishnah. A divorce document has two parts. The first half, the toirif, which contains particularities of the divorce document, the specific names, the date, etc., and the tofes, which is the universal wording that's in basically all divorce documents. If a scribe is just filling in the lower tofes parts on a bunch of documents, he must leave the spaces of the names and date blank. If a similar thing is being done by a loan document, the space for the names, price, field designation, and date must also be left blank. This was done to fix a difficult situation, which will be explained. It's actually debated, however. Some say none of this is allowed, some say it's only not allowed by a divorce document, as the woman says it must be written for the woman's sake. The Gemara says that some add that the words, "you are hereby permitted to every man," which is the main part of a divorce document, should also be left blank to be filled in with the intent for the correct woman when it's actually written, even as the witnesses of the delivery are the ones actually severing the marriage. The necessity for this statement is explained. The notion of fixing a difficult situation, as mentioned, was for the scribe to make things easier for him. The opinions that disallow writing a divorce document in such a manner do so, as they hold that writing the bottom part of the document will lead a person to accidentally also write the top part. The opinion which additionally forbids doing this with any document is as he holds that will lead to a person also doing this by a divorce document. Some say the issue is that the whole document must be written for the sake of the woman. Some say the issue is the scribe's wife might overhear him writing the divorce document and think it's for her, and it could cause a fight. Some say the notion of fixing a difficult situation, as mentioned, allowing this practice, was to prevent the woman from going undivorced, for instance, to allow the husband to find somebody who can write the document in this easier method. In regards to marking the date on the document, the reason for this was described earlier, but by the divorce from a betrothal, where those explanations just don't apply, it's done so that people will know the divorce was after the conception of a child. We rule like the opinion that the main bulk of documents can be written beforehand to be filled in with the specific names and dates later, besides for the divorce document where that's not allowed, although others do still disagree. New Mishnah. If a man's agent was bringing a divorce document to his wife and he lost it, if he immediately found it, it's still valid. If not, and it takes a while, it's invalid, as it could be that it's somebody else's document with the same name. If, however, it was stored in a specific type of container that the agent recognized, it would be valid. The Gemara quotes a different discussion that seems to imply we are not concerned about finding an identical divorce document during travel, but that's explained to be where there's no caravan. Unlike here, where we're discussing where it's within a caravan, so the odds of somebody having a similar divorce document are a bit higher. Related points are discussed. There's further debate on these cases and particularities between unique cases. Some say the difference between cases is the one which said you can reclaim a lost divorce document is where he's able to identify it based on a little hole specifically next to a particular letter. Whether or not a broader identifying mark, like a hole anywhere on the page, is sufficient, whether under biblical or rabbinic law, is debated from particular cases. We said the lost divorce document can be used if it was found immediately. There's debate as to how much time approximately this is. Some say less than the time for a caravan to have passed by a pitched camp. Some say so long as nobody else has passed by yet. Some say so long as nobody has stayed there. Some say it's the time necessary to write a divorce document, some say it's the time necessary to read a divorce document, and some say it's the time necessary to write and read a divorce document. It's held that even if it's lost for a while, but it can be identified with specific identifying marks, such as mentioned, a hole next to a specific letter, it can still be used once it's found. In regards to the ruling as to what's held to be considered to be immediate in regards to finding the divorce document, some say it's so long as nobody's stayed there, some say it's so long as nobody's passed by there. It also gives definition to the containers that the document can be found inside of in the cited case by the Mishnah. New Mishnah. If an agent was bringing a divorce document and the husband, when he gave it, was old or sick, the agent can still deliver the document to the woman with the valid presumption that the husband was still alive. This is a similar application by other laws. For instance, if a non-Kohen woman married a Kohen and the husband was abroad, she can assume her husband is still alive and eat terumah tithes. Or if a person sends his chatas offering to the temple from abroad, the Kohanim in the temple can still offer it, assuming the sender is still alive. The Gemara says an opinion that, however, we do not assume a person will still be alive if when the agent left, the man was over 80 or in his death throes. There are sources which say that we do still assume the husband's still alive, even if he's way over 80, but that's possibly where the man was particularly noted for his longevity. It cites a different case where it implies that there is actually a concern of a husband dying by giving his wife terumah, but that's said to not be comparable to the delivery of a divorce document through an agent, where such a thing cannot always inherently be a concern, or else the whole concept just wouldn't be possible. There's further points on this. There's additional discussions mentioned by the case of the delivery of a chatas offering, as the person bringing it must lean on it. It's either where he sent it with a woman who could do that for him, or it's a bird chatas offering which is not leaned on. It mentioned this principle of not assuming the sender is dead by a divorce document, and then also by terumah, where the woman can just choose to not partake in it. And it also taught the chatas offering case to show that by a bird offering it can still be brought inside even though there's a doubt if the sender is alive, which makes the animal now unconsecrated and not allowed to be brought into the temple courtyard. So it says there is no such concern. New Mishnah. It was held regarding a town besieged by an army, a ship in a storm, and somebody being tried for capital punishment. They are still nevertheless presumed to be alive. If the town was captured by the army, the ship is lost at sea, or the person is going out to be executed, they have the stringencies of somebody that's alive and the stringencies of somebody that's dead apply to them. For instance, a non-Kohen woman married to a Kohen, or a Kohen woman married to a non-Kohen, they cannot eat terumah in this situation. The Gemara clarifies the case of being tried for capital punishment is specifically by a Jewish court. If it was a non-Jewish court and he's been sentenced to death, you can just assume that they'll follow through with that and treat him like a dead person. This is assuming the verdict has been signed, so that way there's no concern of them taking a bribe. It cites some related cases discussing whether or not somebody died or was executed by a court, and it's held that we would believe non-Jewish people if they casually mention that somebody died. However, there is a concern by if they're involved with the court function of the actual execution, as they're not automatically believed if they say they executed somebody, as they were involved with the matter, so therefore their testimony is somewhat biased. There's further discussion on this. New Mishnah. If an agent was bringing a divorce document within Israel and he got sick, he can give it to a second agent to deliver it. If the husband told the first agent that he should collect a specific object from his wife, the agent can't have somebody else deliver the document, as the husband wanted specifically this agent to collect the object from his wife. The Gemara says this principle applies only if the first agent became sick, not in other cases. It also said to not apply if the husband specifically told the agent that he should deliver it, according to some, the wording of which is debated. It also brings a different case where the husband informs agents to write the divorce document, and it learns in that case that they can't give the documents to secondary agents, which seemingly contradicts our case, but that's explained to be unique, where clearly the husband, as he's having others write it, is embarrassed, and he wouldn't want other people getting involved in this whole situation. Alternatively, it's different here, as the agent was given an actual document, and by the other case, he was only told something to write a document, which he then delivers. There's practical variation by a gift document, which is debated if it's considered to be similar to a divorce document. In regards to the last ruling, that if the husband told his agent to pick something up from his wife, only he can do it. Some derive from this that a borrower or renter cannot lend or rent the objects to other people. Others disagree that this is the source for this ruling, although it's debated. New Mishnah. If an agent was bringing a divorce document from abroad, this time not within Israel, and he got sick, he can give the document to a second agent, and the first declares before a court that it was written and signed in his presence, although the second agent doesn't need to do this when he actually delivers it. He just needs to say that he's an agent of the court. The Gemara says it implies that the second agent can then go and appoint a third agent, but it said that this must be done before a court. It also says If the agent is delivering the divorce document within Israel, he can appoint an agent who can appoint an agent, etc. Although if the first agent dies, the remaining agent will lose their authorization. Others disagree and say they would only lose authorization once the husband dies. It provides a few cases of these instances occurring. It also explains how there is no concern of the husband fixing his relationship with the wife in the meanwhile and invalidating the agent's need to bring the divorce document. This is qualified. New Mishnah. People need to give tithes to Kohanim, Leviim, and the poor. So, if somebody lends money to a Kohen, a Levi, or a poor man, he can hold that the necessary tithes, which they'd be getting from his crops, will instead just be kept by him as repayment for the loan. Anyways, he can make these designations assuming the debtors are still alive, with no concern that the Kohen or Levi died in the meanwhile, or that the poor man just became wealthy. If they did wind up dying, the lender must get permission from their heirs to take their tithe portion as payment. This does not need to be done if the initial deal was made before a court. The Gemara suggests that this deal, that the lender can retain the tithes as repayment, is permissible even though the tithes haven't yet been designated to go towards the specific Kohen or Levi, either as the lender here is good friends with the Kohen or Levi, so it was definitely going to go to that guy anyways, or the ownership of the portions was given to the borrowers through somebody else, so they have legally acquired it, or it's a rabbinic institution that this is a valid acquisition. It explains why these opinions disagree with each other, along with some related points in this case, such as that he can fix the price of the tithes of the produce at a cheaper option, which can be done even once the price drops, and there's no principal interest applying to any of this. It's also said that he cannot retract from this agreement, although the Kohen can retract on his end. There are additional points. It discusses this further, and also in regards to collecting his payment from the heirs if the man dies, as mentioned in the end of the Mishnah. There's additional points on giving tithes, such as specific cases of concern about a lack of tithes taken from an amount of given produce, which are further qualified. New Mishnah. If somebody sets aside fruits or coins to separate necessary tithes from them, and they're not right before him, he can separate the tithes, assuming the fruits or coins still exist. If, afterwards, he finds that they were lost, he must be concerned that they were lost within the time of his tithe designation within a 24-hour period. A related topic, there are 3 points that wine must be examined to make sure it's not turned to vinegar by the blowing of the east wind after the holiday of Sukkot, at the time of the budding of berries, and at the time that liquid enters unripe grapes. In regards to the designated period of 24 hours, some say this means there is concern by his tithing 24 hours before he found that the produce went missing. Some say it's 24 hours after, although it's disputed based on the wording, and there's debate on these times. In regards to checking when the grapes go bad, some add specific times when grain and wine can be sold 3 times a year by particular seasons and holidays, which is explained to refer to times when a partner can sell those produce without consulting the other partner. It also cites many verses and discussions on the east wind and upon the other winds and their importance, the harshest of which is said to be the south wind, which is blocked by the angel Ben Nates to protect the world. It also goes through the negative effects of the east wind, which causes decay in many things, and it cites verses on this topic. There are further instances of this given, and that's the end of chapter 3. Chapter 4 of Tractate Gittin goes through additional laws on the bringing of the divorce document and points on its nullification when it's being brought by an agent. The first Mishnah says, if somebody sends a divorce document to his wife through an agent and he bumps into the agent before he delivers it, or he sends another agent to run and catch up to the first, he can tell him to make the divorce document void and it's been nullified. If the husband or his second agent reaches the wife first and tells her the divorce document that's going to arrive soon is void, it's nullified so long as it hasn't arrived yet. If it had, it's too late. Additionally, as the agent is traveling, the husband could convene a court elsewhere and nullify the divorce document where he is, although it was later decreed that this was not allowed as it could cause many issues. The Gemara says the wording implies that even if the husband bumps into the first agent by chance, he could nullify the divorce document without concern that he's just trying to annoy his wife throughout this whole process. The fact that he's allowed to send a second agent shows that his orders to the first agent do not override the orders of the second. Additionally, it taught the case where the husband reached his wife first to show, again, by here too, there's no concern that he did this to mess with his wife. It also shows that this is not a concern by him sending the second agent to his wife, even though he only did it through an agent. Further, it specified the husband can't nullify the document once it's actually reached the woman, to show that even if the husband is clearly rushing to try and annul it, but just doesn't get there in time, it nevertheless still would go through. It also discusses specific wording the husband should use to nullify the document. It works to say things like, the divorce document is void, or I do not want it, But to say things like the divorce document is invalid or it is not a divorce document, that does not work. These phrases are additionally qualified. Additional particular phraseology are discussed. If the husband cancelled the divorce document, it's debated if he can then later go and reactivate it. It's held that he can, although it is discussed. Prior to the annulment of the principle that the husband can just bring together a court to annul the document right where he is, it's debated if this court must consist of 2 or 3 people, as to if that's considered to be a legal court for this. They argue over sources as to the number of judges required in various circumstances. In regards to the prohibition of this practice of no longer allowing the annulment of a divorce document from far away with a personal court, this was done to prevent possible illegitimate children, as the wife wouldn't know that the divorce document she received was cancelled, and then she might impermissibly remarry. Others say the concern is the inverse, that wives who were divorced via agent won't remarry out of concern that their husband undid the divorce with his own court. The debate between these is as to whether the woman will find out about this via the information spreading, depending on whether this occurs if the annulment was done before 2 or 3 witnesses. After the institution of this, that it wasn't allowed. If the husband did nullify the document with his court anyways, it's debated if this now has any validity. Some say no, as the betrothal and divorce function through the sages, which means they can retroactively nullify the divorce, as even if the betrothal was done through cohabitation, they could just retroactively make it that their act of cohabitation was just a form of illicit relations, meaning they were never legally married in the first place. If a husband told 10 people to write a divorce document for his wife, some say he can nullify this before only one of them, others say that all 10 must be present. This disagreement is based on whether partially invalidated testimony is considered to be totally invalidated or not. Or possibly both opinions agree that partially invalidated testimony is not invalidated, and the disagreement is over whether something done before 10 people must be undone before all of them. There is a further question depending on which of these 2 issues you hold exists, as to if the husband said all of them should write the divorce document. It discusses this while comparing it to a number of related cases which are qualified. There are additional points. There's a quoted case where a man sent a divorce document to his wife, so the agent took it and brought it, but the wife said to give it to her the next day, so the agent went back, and the man said, "Thank God," essentially as he was happy it wasn't delivered. However, it's debated if him saying "thank God" was sufficient to nullify the document in regards to whether disclosure of intent is sufficient to nullify the document. They debate this from further sources. It brings a few particular cases to illustrate this principle. In conclusion, it says that we hold that a divorce document can be nullified before 2 people, along with this opinion's statements by the other arguments, and additionally that we hold with the opinion that disclosure of intent by a divorce document is just disregarded. New Mishnah. It was originally done that on the divorce document the husband would write the names which they were known by in the place that the document is written, along with their cities, but it was then instituted that they should write their names and any other names they're referred to by also to resolve any potential issues. The Gemara further describes this opinion with some instances, and that he writes all of the names that he's known by with the name that they're primarily known by first. New Mishnah. A woman collects payment of her marriage contract through an oath if it's from orphan's property. Some courts wouldn't administer this oath, so it was said the woman should just accept any vow the orphans want her to take in regards to this and then collect the marriage contract. Anyways, the witnesses sign their names on the divorce document, even though it's not strictly necessary to prevent any issues. There was also a document established that prevented the sabbatical Shemitah year from repealing any outstanding debts to resolve potential issues. The Gemara says, the first point applies by general collection from orphans, but it specifically mentioned the widow to show we're not more lenient here to help her get remarried easier from these new assets. It cites cases which show why the courts don't force widows to take these oaths, one of which was a situation where a woman accidentally swore falsely during testimony about not having benefited from a gold coin, when, unbeknownst to her, she actually had by mistakenly baking the coin into a loaf of bread. So because of the repercussions of this incident, they no longer required specifically widows to take oaths, not even when taking property from orphans who she takes care of. Some hold that you can nevertheless have her take an oath outside of court. It mentions related incidents. Some simply ruled to allow the widow, when collecting this property, to take a vow in court as the orphans require, as specified in the Mishnah, or to just take an oath outside of court. This all applies by a widow. By a divorcee, she can be made to swear. The point is debated. In regards to the opinion that the widow should take a vow as dictated by the orphan to collect their property, some hold this cannot be done if she already remarried. Others say she can, and the husband won't be able to revoke the vow as it will be made in public. This is discussed, and there's a debate if, when annulling a vow, if the person needs to give the details of the circumstances around the taking of the vow. Some say no, as he might not give all the details. Some say yes, as the vow could have been taken in a forbidden manner, and the annuller should be informed of that if that was the case. This is further debated. It was said that witnesses sign their names on the document to prevent any issues. This is like the opinion that it's not typically required to have them sign the document, as the witnesses of the delivery are the ones who sever the marriage. and the other witnesses of the actual signing were just rabbinically instituted. Some sages would sign their names in such instances using a mark or symbol, like a fish or a sail, but that was publicly known about, so it was accepted. The points on the Shemitah sabbatical year not overriding lending documents is a principle known as prusbul, which was instituted. Essentially, as the Shemitah year annulled any of such documents, people wouldn't lend each other money as the year approached out of concern that they wouldn't be repaid. So the prusbul declaration essentially submits the debt to the court instead, which is not annulled within the coming of the Shemitah year, which is signed by witnesses, and they can then collect the money afterwards. This was instituted after the Shemitah year principle became one of rabbinic law only, which is why it was allowed. Alternatively, it functioned as the court is permitted to just declare property ownerless, which is sourced from some verses. There's some discussion on the point of prusbul, along with points on etymology there. For the points, it said that prusbul is only declared if the borrower has land to back his debt, and if he doesn't have any at all, the lender can give him ownership of a tiny piece of his land, which he doesn't even need to physically give over. Details of this principle are discussed along with additional discussion on the notion that the Shemitah sabbatical year cancels all withstanding debts. There are additional points on these laws. New Mishnah. If a Jewish person's Canaanite slave was taken captive and other Jewish people ransomed him, if they ransomed him as a slave, then he's a slave. If they ransomed him as a free man, then he's free. Others say he's always ransomed as a slave. The Gemara explains that this is prior to where the owner abandoned the slave. And if he was ransomed as a free man, he would still not be enslaved according to the first opinion, as they hold that the first man's ownership was revoked. So that way people will be more likely to ransom slaves. The other opinion disagrees, saying there's a mitzvah to ransom slaves. Others hold the opposite, saying this case was after the first owner abandoned him, so he's either enslaved again by the second man or not, and the other opinion disagrees to prevent the potential likelihood of slaves giving themselves up to bandits to be able to escape. These opinions are debated on further. There's further discussion. Some hold that if such a slave is captured and he then escapes on his own, he's considered to be emancipated, and the master must write him a emancipation document. There are additional points along with a few particular cases brought. There's more of this. Some say it's actually a transgression to free a Canaanite slave. Others disagree. It's debated. It said if a slave is consecrated to the temple, he goes free, as it can't be the man himself, and it wasn't the value of the man either. So it's interpreted to mean that he's saying he should become like a person who's consecrated, like a free Jew. It's also said if you declare the slave ownerless, he's free. There's additional points on these laws. The points and principles of the consecration of a slave and its legal validity is debated further, along with declaring a slave to be ownerless as to whether he additionally requires a document of emancipation. There's further points, and it describes which laws by this we hold. Like, there's additional discussion on certain actions a slave can do that, if done, causes us to presume he was freed. For instance, borrowing money from the owner, being the administrator of his property, wearing tefillin, and others, along with debate if a person can make his heirs emancipate his slaves after his death. There are additional points, along with a few particular instances. There are further laws on the emancipation of a slave. New Mishnah. If somebody designated a slave as collateral and then emancipated him to resolve potential issues, the owner must have the slave go free, and it's debated who writes the note of indebtedness, either the slave or the emancipator. The Gemara goes through this case and clarifies points. It's the first owner who's emancipating the man, and the slave is not obligated at all to work for the second, but to prevent issues, the second man frees him anyways. The remaining points in the case are discussed along with points on using property as collateral, such as if the designated property is flooded. There's debate if the creditor can collect from other properties, along with additional points. New Mishnah. Somebody who's half slave and half free. Beis Hillel says he works one day for his owner and one day for himself. Beis Shammai says there's an issue as to how he can marry, so he says that the owner must free him in exchange for half the slave's value, and Beis Hillel changed his ruling to agree with Beis Shammai. The Gemara states additional discussion on these principles. There are additional laws and points by the concept of half-freed slaves. There's more, and then how he or his half-owner are repaid if he's killed by somebody's ox or otherwise injured, and if a freed slave's owner is a Cohen, if he hasn't yet been emancipated with a document as to whether he can still eat truma. There are further additional points on all these laws, and additionally regarding betrothal of a half-slave and similar. There are additional points. New Mishnah. If a person sells a slave to a non-Jewish person or to somebody who lives outside of Israel, the slave is automatically freed. The Gemara says an opinion that by the first case, he should write a document which says he does not retain ownership if the slave escapes. This goes further. There's additional discussion and debate if selling a slave to a Kuthian or apostate has a similar status to selling it to a non-Jewish person. If non-Jewish bandits captured a person's slave, it's argued if he can be paid for the slave by the bandits, as this would typically not be a permitted sale. Additionally, if a person does sell a slave to a non-Jewish person, which is ruled to not be allowed, as the slave won't be then keeping Torah and mitzvahs in such a situation, so he must buy him back for whatever the price. Some say there's a less severe penalty here, as this is uncommon. There's additional points on this and on the prohibition to sell a slave to a person who lives outside of Israel. It's explained that in such a situation, the purchaser is penalized, along with some related incidents and expansion on some particular verses. New Mishnah. Captives cannot be ransomed for more than their value to prevent any further potential issues. Additionally, it's forbidden to help captives escape, which is explained to be to prevent any future or remaining captives from being mistreated further. The Gemara further describes these points along with a few particular incidents. There's a story where a sage saw that the daughters of another sage would stir a boiling pot with their hands without being harmed, so he assumed that they were very righteous. Once all three of them were captured, and a raven and then a dove spoke to the sage telling him to flee. So he went to check on the other daughters, and he overheard them saying that they were marrying their captors, so he escaped on his own, and when the two daughters eventually returned, he found out that they had been stirring the pot with sorcery. New Mishnah. You cannot buy Torah scrolls, tefillin, or mezuzahs from non-Jewish people for more than their value to prevent any potential issues of theft and ransoming of such scrolls. The Gemara discusses these points and mentions that a Torah scroll written by an idol-worshipping priest should be burnt, and if by a non-Jewish person, it should just be stored away. And if it was found in the possession of an idolatrous priest, it should be put away. And if it was by a non-Jewish person, some say it couldn't be read from. It cites related points on this topic and says you can pay up to a trapaic coin above their value, but also not to undervalue them either, as the sage did this once. And the seller who was selling a pair of tefillin got upset and angrily threw the tefillin into a river. New Mishnah. If somebody divorces his wife due to her poor reputation or due to a vow, he can't remarry her. Some say he can if it was a private vow. Some say it's allowed if it was a vow that does not require asking a sage. Some disagree. And there's a case where a man vowed against benefiting from anything unless he divorced her, and he was allowed to remarry her to prevent potential issues. The Gemara further describes these cases and the different methods and principles of these vows. It debates if the public vow is before 3 or 10 people, which is based on verses along with the remaining points. The last case is also qualified. It debates if the point on preventing potential issues applies to the first case or to the last. New Mishnah. If somebody divorces his wife because he found out that she was an Ilonis, a physically unique woman with male characteristics, it's debated if he's allowed to remarry her. If she remarries and has children and demands her Kosovo marriage contract payment from the first husband, he can tell her it would be better to not require this, as he can retroactively cancel his divorce based on this new information and therefore make her children illegitimate. The Gemara discusses these points. New Mishnah. If somebody sells himself and his children as slaves to a non-Jewish person, they're not redeemed, but we do redeem the children after the father passes. The Gemara says an opinion that this rule only applies if he's done this multiple times. Related incidents are cited. There is a related story where the sage Reish Lakish, who was a bandit chief when he was younger, allowed himself to be captured by a cannibal tribe and brought a bag and a hard stone ball. On the day he was to be killed, they told him that they had a tradition that he would be granted one final request to the man that they'd be eating to gain forgiveness. So he said that he wanted to tie them all to chairs and hit them with his bag. So they agreed, and then he put the stone in the bag, and then he beat them all to death with it. Anyways, he eventually became a great sage from a later story and lived a very simple lifestyle. New Mishnah. If somebody sells his field to a non-Jewish person, he must purchase and bring the first fruit tithes of the field from him to prevent potential issues. The Gemara explains the sale of such land does not reduce the sanctity of the land, and the non-Jewish person acquires it fully. Others disagree with this point, and it's debated based on the interpretation of a verse. It discusses how there's no reduction in sanctity after such a sale in regards to collecting tithes. There's further discussion on this and variation in regards to the property that's in Syria, which has a slightly different status. Further, the requirement to bring the first fruit tithes from such a sale is said by some to be to prevent potential issues, not as a biblical requirement. If a person sells the rice to the produce of his field, but retains the field itself, it debates if the buyer needs to separate the first fruits with a blessing or not, as he doesn't actually own the field. This debate is based on whether a person who purchases an item for its produce, whether that's considered to be an acquisition of the item itself or not. It debates this principle from several sources. There's additional discussion on this, the Shemitah sabbatical year, and on the Yovel year, and this goes further. And that's the end of chapter 4. Chapter 5 of Tractate Gittin covers some additional laws of divorce, some further rabbinic institutions to resolve financial-related issues, and a lengthy portion which goes through many stories and anecdotes relating to the destruction of the Second Temple. The first mission says there are general types of people that are owed money. Somebody who they or their property was damaged, somebody who lent another person money, and a woman who receives her marriage contract. It was instituted that the damaged party collects payment from superior quality land, a lender collects payment from average quality land, and a woman collects her marriage contract from inferior land, although others hold that she also collects from average quality land. Another institution, a creditor cannot collect payment from encumbered properties if the man owns unencumbered property, even if the unencumbered ones are of inferior value. Another institution, creditors can't collect payment of their owed debts from orphans unless it's inferior quality land. Another institution, to prevent potential issues, we don't collect from encumbered properties to give food for land improvement or to provide food for a man's wife or daughters. Another institution, somebody who finds a lost object, he's not required to take an oath that he's returning everything he found so as to prevent issues. The Gemara says the point that damages are collected from superior quality, this opinion holds that the definition of superior quality land is assessed according to the damager's properties. Others disagree, saying it's a biblical law that it's assessed according to the damaged individual's properties, which is described described. It discusses exactly which case this latter opinion is referring to, and it said that the cases where the superior quality land of the damaged property is comparable to the inferior land of the damager. So this opinion would hold is paid according to the damaged individual's property. Others would say it's assessed from the damager's property. This dispute is based on the explanation of particular words from a verse. These opinions are further described also in regards to the value level of property collected by the temple treasury when compensating from damages. This is further described. There was also the debate if a woman's Katsoba marriage contract is collected from inferior or average property. The logic of inferior land is that a woman wants to marry, so she's not going to refuse to get married if her contract payment will be through inferior land. Additionally, a man can divorce his wife only voluntarily, which can prevent situations of the wife antagonizing him while waiting for divorce. Further, the opinion that said that the contract is collected from inferior land, they hold that's only if the land is being collected from orphans. If it's from the husband itself, they would still hold it's taken from his average quality land. This point is further argued on. It's additionally proven that a divorcee collects her marriage contract from her husband's inferior land. By the point that a creditor collecting land from orphans only gets from inferior land, some hold this even applies if the document specifies he could collect from the superior quality land, although others disagree. The point is further argued on. In the end, it's held that a creditor can only collect from inferior land from orphans, even if they're adults, and he must take an oath while doing so. It was also stated that creditors can collect from encumbered properties if the man owns unencumbered properties. It debates if this would also apply if the debtor was given a gift of land, if that also can't be collected from first. This is argued on further along with the remaining points. There's additional discussion on particularities of these laws. There's further points on the laws of collection of creditors. New Mishnah. If orphans rely on a householder to take care of their affairs, or their father had appointed an administrator over them, that man is responsible to tithe their produce. If this administrator was appointed by the father, he needs to swear to the orphans that he hasn't kept any of their property. This is not necessary if he was appointed by the court. Others say it's the exact inverse. The Gemara says this is where the tithes produce is to feed the orphans. The administrator wouldn't be able to tithe it if it was to be stored until the orphans grow up. It cites sources for this. It further qualifies what an administrator is allowed to do with the orphans' property, whether he can litigate cases with them, whether he can sell or redeem the property, and similar. It cites a number of related instances along with some general issues of purchasing property from orphans, such as that if such a purchase is made and the property goes up or down in value and the orphans decide to cancel the sale, the orphans will either get the increased value or will have to be paid to make up for the decreased value. There are related similar laws. This goes further. It mentions some particular instances along with some additional remaining laws and clarifications. It holds with the opinion of the inverse, that the administrator is only required to take an oath if he was appointed by the court, not by the father. New Mishnah. Another institution, if somebody made somebody's produce impure, or mixed teruma tithes into somebody's produce, or made somebody's wine into nesach, using it for an idolatrous libation, which makes those foods inedible. If this was done accidentally, he's not liable to repay them. If it was done intentionally, he would be liable. The Gemara debates if the wine here is being used for an idolatrous libation, or is being mixed with such nesach wine, which has variation in the monetary compensation. This and the sources for the principles of the Mishnah are discussed. It debates by these principles as to whether unrecognizable damage is legally considered to be the same as actual damage, which is argued on further based on some related discussions. There's additional points on all this. This is all further qualified. New Mishnah. If a Kohen made an offering with the improper intents, messing it up essentially, if this was done intentionally, they're liable. The Gemara debates when a Kohen in this situation is believed if he did this. Some say not, if the object is not in his control when he informs somebody. Others disagree, and it's argued on. It also brings a few particular instances of this concept actually occurring. New Mishnah. Some hold, if a father signs a betrothal on his minor deaf-mute daughter so that way she'll get married when she eventually gets older, she can be divorced with a divorce document. Similarly, if the family of an orphaned minor girl wants to have her marry a Kohen, as discussed in earlier tractates, essentially a legal contract which makes her wait until she becomes an adult, at which point she can refuse to go through with this marriage or agree to it. She can eat truma here at this point, and if she dies, the husband inherits her estate. Additionally, regarding a stolen crossbeam that was built into a house, he instituted that the beam is repaid in value to encourage people more to repent and to not have to tear down their house to return what they had stolen. Additionally, regarding a stolen chatas offering, that status is unknown. It atones for the benefit of the altar. The Gemara additionally qualifies these rulings. These are explained further. New Mishnah. After the destruction of the Second Temple and the following diaspora, many non-Jewish people started living in the abandoned portions of the land. The following laws apply outside of Judea and also within Judea after the period where people were being killed during the war. Anyways, If a person acquired land from a person who had taken land during the war and then legally additionally acquired it from the original Jewish owner, that's not valid. He has to return it. If he acquired it from the original owner first and then the second person who took the property, that would be a valid acquisition. Similarly, if somebody acquired land that was used as a mortgage for a mortgage contract from a husband and then from his wife, that's not valid. If he acquired it from the wife and then the husband, that is valid. It was later instituted that if somebody purchased land from somebody who acquired the property during the war, he should give a quarter of it to the original owner, so long as the original owner does not have the means to actually acquire the land for himself. Additionally, if the new owner of the land had it for 12 months, the purchaser gets it and gives a quarter of it to the original owner. The Gemara explains why this principle didn't apply in Judah during the actual war. Titus, the Roman emperor who had led the siege and destruction of Jerusalem, had instituted a few laws. First, that whoever doesn't kill a Jewish person should be executed, then whoever kills a Jewish person would be fined, and then whoever kills a Jewish person would be executed. So during the periods of the first two rulings, if somebody was attacked for their land, they would fully and sincerely give the land over, meaning it would no longer have this particular legal status where he didn't fully give it up mentally by the later situations. Further, in regards to the actual destruction of Jerusalem, it said this occurred due to the incident with Kamsa and Bar Kamsa. The region of Har HaMelech was destroyed due to the incident with the rooster and the hen, and the city of Beitar was eventually destroyed due to the incident involving a carriage, all of which will be recorded. First, the incident of Kamsa and Bar Kamsa. There was a very wealthy man who was good friends with a man named Kamsa and enemies with a man with a very similar name, Bar Kamsa. So he tried to invite his friend to a banquet and accidentally invited his enemy, Bar Kamsa. So Bar Kamsa arrived and the rich man became furious and immediately tried to kick him out. Bar Kamsa, embarrassed, begged to stay, offering to pay for his meal, then half the banquet and then the entire banquet. The rich man refused and forcibly ejected him. Bar Kamsa left ashamed and angry at the sages who were at the meal and did nothing. So he went to the Roman officials and spread slander that the Jewish people had begun a rebellion and offered to prove it by having the Romans send a delegation to bring an offering in the temple. So they sent a fine calf, and along the way, Bar Kamsa made a blemish on the calf's lip, making it unfit for offering. When it was brought to the temple, they debated if they should offer it anyways due to the unique circumstances, but they decided against it. Some suggested just killing Bar Kamsa, others rejected this, and it was said that this rejection resulted in the destruction of the temple, Jerusalem, and the exile. Nero, the Caesar, was sent to attack Jerusalem. There's some debate as to if this refers to the actual Caesar Nero, or if this was some general who was also named Nero, but anyways, he arrived and shot an arrow in all four directions, and they all landed by Jerusalem. A child walked by, and he asked what verse the boy was reading, and the boy said, "I will take my revenge against Edom through the agency of my people Israel." So Nero realized that God wanted Jerusalem destroyed, but he would also destroy whoever did so. So he ran away and converted to Judaism, and the sage Rabbi Meir was his descendant. So instead Vespasian was sent, and he laid siege for 3 years. Now, Jerusalem had three wealthy men, Nakdiman ben Gurion, Ben Kalba Savoa, and Ben Tzitzis HaKeses. These are all actually nicknames referencing their great wealth. Collectively, they sustained the city throughout the siege with wheat and barley, wine, salt, and oil, and wood. Together, there was enough food and supplies to keep the people of Jerusalem safe for 21 years. However, of the many factions within Jerusalem, there was one group called the Beryonim, and they refused to make peace with the Romans or to hold out with their supplies for the siege. They wanted to fight, and they wanted everybody in the city to join them. So they went and burned down all of the storehouses, resulting in there being no food in Jerusalem at all, and a severe famine. It gives an instance of a wealthy woman who went to buy food from the market, and each time she went, there was less and less until she walked the city herself, stepped in waste, and died. Although before she did so, she threw out all her gold and silver into the streets as they were of no more use. One of the sages, Rev Tzadok, fasted for 40 years to try to prevent the destruction of the temple, and ended up being extremely delicate to the point where he could only eat fig juice. Anyways, the sage Rabbi Yochanan ben Zakkai secretly met with his nephew, a man named Abba Sikra, who was the head of the Beryoni group. Apparently things were pretty out of hand, because he said if he tried to get them to stop, they'd just kill him. So they worked together to try and sneak Rabbi Yochanan out of the city. Rabbi Yochanan pretended to be sick for a while, and then kept an animal carcass in his room to spread the rumor that he had passed. His students then carried him alive in a coffin outside of the city. The Beryonim, who were guarding the exits so that way nobody could escape, wanted to stick spears, or at least hit the coffin to make sure Rabbi Yochanan was actually dead, but they argued against it as it would be disrespectful. Anyways, once he was outside, Rabbi Yochanan ben Zakkai entered the Roman camp and greeted Vespasian, calling him a king. Vespasian reprimanded him, saying he wasn't a king, and if he was, then why are you only coming now? Rabbi Yochanan responded, saying that Vespasian was destined to become a king, as all the verses reference Jerusalem falling only to a king, and he had only come now due to all of the issues with the Beryonim. Vespasian asked, via metaphor, of a keg of honey and a snake, essentially why they didn't destroy the walls of Jerusalem to get rid of the Beryonim, and as they were discussing this, a messenger arrived informing Vespasian that Rome had just appointed him as the new Caesar. This, by the way, lines up with the historical accounting. This whole siege occurred during the year of the 4 emperors, the last of which was Vespasian, who was summoned away from his siege at Jerusalem and sent his son Titus in his place. Anyways, after further discussion, Vespasian offered one thing to Rabban Yochanan ben Zakkai, and knowing that asking to spare Jerusalem would be rejected, he requested that the city of Yavne, containing the Torah sages, that it should be spared, and that the family of Rabban Gamliel should be spared, and that he should also provide doctors to care for the sage Rav Tzadok, which was granted. So Titus was sent and eventually broke the siege, and as the war was fought in the temple and within the streets of Jerusalem, it said that Titus took a harlot into the innermost part of the temple, spread out a Torah scroll, and cohabited with her on it. He also slashed the pareches, the curtain, with a sword, and blood poured out of it, and Titus thought he had killed God. In the meanwhile, the war was lost, and basically every remaining person within Jerusalem was either killed by the Roman forces or enslaved. He then wrapped all the utensils of the temple into the paruchas and brought them on a ship back to Rome. It said that a hurricane threatened Titus's ship, and Titus claimed that the Jewish god is of water, as he had killed the Egyptians with water and the armies of Sisera. So it says a heavenly voice declared, "O evil man, the son of an evil man, a descendant of the evil Esav, I have a puny creature in my world, and it is called a gnat. Go up on dry land and fight it." Anyways, Titus arrived off his ship, and a gnat flew up his nose and sat there picking at his brain for the next 7 years. At first, it would be silenced during the banging of a smith's hammer, but eventually it got used to it, and then never stopped its incessant chewing. One surviving sage was among the nobles of Rome, and he reported that when Titus died, they split his skull open and found a gnat inside, swollen to the size of a swallow, and some add that the gnat had a copper mouth and iron nails. Another incident, Onkelos, the sage who would eventually write the Aramaic translation of the Torah, was Titus's nephew, and before he converted, he decided to do some necromancy to see if it would be a good decision. He summoned his uncle, Titus, and asked him who is prominent in the world to come, and Titus said Israel. He asked if he should join them, and Titus said that they have too many laws and you won't be able to fulfill them, but he should attack them, as it said whoever does so will become a leader. Onkelos asked Titus what his punishment is, and he said that every day his ashes are regathered and judged, and then reburnt and rescattered across the 7 seas. Onkelos then raised the wicked prophet Balaam, and asked similar questions, got similar answers, and was told that Balaam was punished by being boiled in semen. Lastly, he brought up Yeshu HaNitzri via necromancy to ask him these same questions. Now, there's actually a lot of debate as to who this Yeshu HaNitzri refers to. I explained this further back in Tractate Sota on page 47a, but briefly, Yeshu HaNitzri is often translated as Jesus of Nazareth, as you'll see in some editions. This is not a very accurate translation, as on top of the word Yeshu just not translating to Jesus, it's a completely different word despite sounding similar. The reference figure also has dates recorded as to when he lived within the actual Gemara, which is around 100 BCE, along with points on his story being mentioned throughout the Gemara, and it being one completely different than the historical Jesus of Nazareth. So, as mentioned, it's actually a subject of much debate as to who this refers to, with no conclusive answer, although whoever it was, we do know that he had to live under the rule of the king Janneus, as mentioned in some other stories from the Gemara. Anyways, with that aside, he asked him who is prominent in the world to come. He said Israel. Onkelos asked if he should convert, and he was told to seek their benefit and not their harm, as touching them is like touching the pupil of God's eye. And lastly, for his actions of mocking the words of the sages, he was punished in boiling feces. However, it does say admiringly about him how even as a sinner, as a Jew, he still gave good advice and sought to help others. Anyways, the other referenced incident was of the rooster and the hen, which caused further destruction. A region had the custom to bring a rooster and hen before a bride and groom as a blessing to be fruitful. Some Roman soldiers were passing by and they stole the birds, so they attacked the soldiers. The Roman armies came, and it says one prayed with the verse, "Do not go forth, O God, with our legions," and was then bitten by a snake in a restroom and died. The Caesar decided to spare the Jewish people here, so they all celebrated, so the Caesar got upset and decided to attack them anyways, and sent 300,000 men and killed everyone on the mountain for 3 days and 3 nights. And those on the other side of the mountain didn't realize what was going on as they were busy celebrating. It gives some details on this region, and it debates if people from the town of Sachania who were destroyed were righteous, and it says that they just hadn't mourned for the destruction of the temple. Anyways, the third incident was the one involving a carriage. One town had the custom to plant a cedar tree by the birth of a boy, and a cedar tree by the birth of a girl, and when they married, the trees would be cut down to build a wedding canopy. Once the Caesar's daughter was riding her carriage through the town, and her carriage broke, so they cut down a cedar tree, city and fix the carriage. So the people of the town got upset and attacked them, so the Caesar then destroyed Beitar, which it describes. And on top of marking the end of the historical Bar Kokhba revolt and the death of Bar Kokhba himself, it says all the residents within were executed until their blood flowed to the Mediterranean Sea, and vineyards of the area were fertilized with all this blood. It cites related verses by the death of Zachariah, whose blood lay boiling on the floor of the temple, and Nebuzaradan, one of the offers of Nebuchadnezzar, slew many over it to try to get it to rest. Members of the Sanhedrin, young men and women, and school children. Eventually it rested, and Nebuzaradan ran away and converted to Judaism. It mentions a few wicked people did such, including the descendants of Sancheriv, who became the sages Shemaiah and Avtalion, the descendants of Haman, and others. It cites many verses which reference aspects of the destruction of the temple. There's a recorded incident where 400 boys and girls were enslaved and being shipped to Rome to become concubines, so they all decided to jump off the boat rather than do such. There's also an incident where a woman with 7 sons was brought before the Caesar, and each was told to bow to an idol. Each refused and was executed until the youngest, where the Caesar even offered to drop his ring on the floor to make it look like the boy had bowed, but he still refused, so the mother told her son before he was executed to inform Abraham when they met that while he had put 1 son on the altar, she had put 7, and then went and took her own life. It expounds on additional verses. It goes through some further points on the destruction of the first temple, on the mass executions, how the Jewish children were enslaved and tied to bedposts to be looked at while the Babylonians had relations, and additionally by the later destruction of Beitar, all the children planned to attack the Roman soldiers with sticks, and in the end they were wrapped in Torah scrolls and set on fire. There's a story of a rumor being told to a sage of an exceptionally beautiful child in a Roman prison, so he traveled to him and asked him about some verses from the Torah to confirm that he was Jewish, and then paid a massive sum to free him, and the boy became a great sage. There's also a story of 2 slave owners that each said that they had a beautiful slave, a man and a woman, so they set them in the same room so that way they'd reproduce, but they were both Jewish captives and Kohanim at that, so they just sat on opposite sides of the room, and when day came, they saw each other and they recognized that they were brother and sister, so they hugged and they both died. Another story, it speaks of an enslaved, beautiful Jewish woman who was the daughter of the Kohen Gadol, who was used for illicit services by her captor and sold, and it speaks of her lamenting this to God. It also speaks of some instances of adultery and how it resulted in the destruction of the Second Temple. After that, it goes back and discusses additional points on the reclamation of property in the region after all these events and the resulting laws. It also says that these principles don't apply in Babylonia. There are additional points on these laws. Additionally, it states that from Moshe until the sage Rebbe, there was not Torah and authority in one person, and it goes through many biblical and historical figures and explains how this wouldn't apply either as there were other great men also in those times or otherwise. New Mishnah. In regards to legal matters, a deaf mute can make hand signals and others can make hand signals to him. Others say they can even just mouth words in regards to the transfer of movable property. In regards to children, they can validly purchase or sell movable property. The Gemara says that the deaf mute would still need to use hand signals by divorce, and it discusses the remaining points. New Mishnah. Some additional institutions which create harmony. The order of reading of the Torah is of a Kohen, Levi, and Yisrael. Additionally, the Erovei Chatzeris should be placed in the house that it typically is. The cistern closest to the irrigation channel should be filled first. Prey caught in traps, or animals, birds, or fish, it's considered theft to steal them. An item found by a deaf mute, insane person, or child are also protected by the laws of theft. If a poor man is collecting field charity of olives on top of a tree, the olives that fell below him are protected by the laws of theft. If poor non-Jewish people want to partake of field charity of any sort, they're allowed to take whatever they want, again, to promote peace. The Gemara additionally qualifies the points on the order of the Torah readings. These principles are discussed further. There are additional points on these laws on the points of the Eruv boundary, on the cistern laws, and the others. It also describes the traps and how all these additional principles of theft apply as listed. Additionally, it says to promote peace, we give charity to non-Jewish poor people right along with Jewish poor people. We visit the non-Jewish sick right along with the Jewish sick, and we bury the non-Jewish dead the same way we bury the Jewish dead. New Mishnah. A woman can lend a person she suspects of violating principles of retaining produce by the sabbatical year her sifter, sieve, hand mill, or oven, although she can't sort or grind with her. Similarly, a person can lend the wife of an ignoramus a sifter and sieve, and can sort and grind and sift along with her up until the point where she adds water to the flour, as this could involve some transgressions. These are all principles to promote peace. Additionally, you're allowed to lend support to non-Jewish people who work the land by the sabbatical year, but not to a Jewish person who has those laws actually applied to him. Additionally, it's allowed to greet everybody, including non-Jewish people, with the traditional greeting of Shalom, which is considered a form of God's name based on some verses, and ask after their welfare to promote peace. The Gemara additionally qualified these principles. The points on the sabbatical year are additionally discussed along with the issues of preparing bread alongside the wife of an ignoramus. This is further discussed, and it says that it's still forbidden to work the land on a sabbatical year. So during that period, a Jewish person cannot work alongside a non-Jewish person who is allowed to work the land then. Additionally, some hold that it was nevertheless improper to give the double greeting of saying shalom twice, although others would frequently wish success to their non-Jewish neighbors, wishing them strength in their work. Additionally, it said that it's permissible to ask after their welfare, obviously, but it's even allowed on their holidays and has no negative connotation, unlike a source which it cites that seemingly disagrees with this. It cites a related incident on these topics, and that's the end of chapter 5. Chapter 6 of Tractate Gittin goes back to discussing the laws of the divorce document and its delivery. The first Mishnah says, if the husband tells somebody to accept the divorce document on behalf of his wife, or to be an agent to deliver it to her, he's allowed to retract it up until the point that it reaches his wife. If the wife sent somebody to accept the document for her, the husband can no longer retract it once it's given to the agent. Therefore, it's possible for the husband to just tell his wife's agent that he's not having him accept it. He should just take it and bring it to her, and then he can retract it up until the point that it reaches his wife. Others hold that even if the wife told her agent to just take the document once the husband hands it to the agent, he's no longer allowed to retract it. The Gemara argues based on the wording, if when the husband told his agent to take the document to his wife, the expression of having him take it, if that's the equivalent to having the agent acquire it legally for her. But this is rejected, and when the agent is told to accept it by the husband, he's authorizing him to deliver the document. It tries to imply from the wording of the remaining parts of the Mishnah that telling the agent to take the document is the legal equivalent of having him acquire it, but it cannot. Additionally, in regards to people who can legally be agents to bring or accept a divorce document, it's known that a man can be an agent to bring a divorce document, and a woman can be an agent to accept one. Additionally, the last suggested case of the Mishnah was where the husband told the wife's agent to essentially become his agent. So this shows that a man can additionally be an agent to accept a divorce document, as additionally seen from other scenarios. It cites additional cases which show a woman can also act as an agent for acceptance and also for delivery. There's an additional ruling if a woman told her agent to bring the document to her, and the agent told the husband that she, the agent, will be the one accepting the document, which is not what the wife had told her to do, and the husband gives the agent the document, but says the document goes to you as the wife said, the divorce document is invalid. This is explained by some to be because the agent is essentially refusing to be an agent to deliver the document back, so it's not being appointed even for this by the husband. If further debate the validity of this concept, there's additional discussion on the phrase telling the agent to take the document, if that's the same legal equivalent of telling her to accept the document. This goes further, and it does conclusively prove, according to one opinion, that saying this divorce document is for you is the same legal equivalent of saying they should acquire it. It debates further the phrase take it has the same legal equivalence. It's also argued between opinions as to whether a woman can appoint an agent to accept the divorce document from the husband's agent. The potential issues with such a situation are the husband will take offense and invalidate it, or that it could be confused with the case wherein the husband placed a document into a courtyard and then that courtyard was given to the wife, including the document, and that's definitely not a legally valid form of divorce. The practical difference between these logics are if the woman appointed her agent first, so that's not comparable to the courtyard situation. There's an additionally cited case wherein a husband sent a divorce document to his wife via agent, and the woman was preoccupied, so she told the agent that he should be her agent to accept the document, and it was debated by many if this was valid. In an additional case, the witnesses of the husband mistakenly wrote the wrong name on the document, obviously invalidating it, and it was eventually ruled that the agents are nevertheless allowed to rewrite the document as many times as they want. The other points are qualified. New Mishnah. If a woman told an agent to accept her divorce document, she needs 2 sets of witnesses to confirm that this occurred. 2 to confirm that she told the agent to accept the document, and 2 to say that they saw the agent then go and accept the document and also tear it. Additionally, it's allowed to be the same 2 witnesses by both, or one of the same witnesses by both. The Gemara says there's a debate if the husband gave a divorce document to a third party, and the husband says it was just for safekeeping, and the third party says it was for divorce, as to who we believe in this situation. Some say we believe the husband, as if he wanted her divorced, he could have just given her the divorce document. Some say the third party, as evidently they were trusted by the husband. Other sources say that we do always believe the third party, but those are explained to be talking about monetary disputes or commercial documents. It further debates if the third party in this instance is believed, and the reason the document had to be torn was that during this period there was governmental decrees against religious observance, so they had to get rid of the documents after use. Additionally, it is agreed that if the wife confirms that the third party gave the divorce document to divorce her with, she's believed so long as she confirms it was given by the husband to the agent while she was actually there. This is because this claim has more believability, as if she wanted to lie, she could have just claimed the husband gave it directly to her. In additional instance, if the husband confirms he had given the document to a third party to divorce, and the third party also confirms that it was given to divorce, and the woman says she was given the document but it was lost, some claim they still require witnesses to prove this, as the document is lost, the third party doesn't have it, and the husband himself didn't directly divorce her. Additionally, there is a principle that we presume an agent has fulfilled his assignment, but that's only if it results in a stringency. Additionally, here we have a greater concern that the woman would lie straight to the husband that he divorced her, as she has a third party to back her claim up. New Mishnah. Regarding a betrothed Na'ara, a woman in a middle stage of adulthood, she or her father can accept her divorce document. Others disagree, saying it's just her father, as there can only be one person with this authority. Additionally, any girl who is not able to take care of her divorce document cannot be divorced. The Gemara explains the logic of these points, and in regards to the situation described from earlier tractates, that if there is an orphaned minor who is legally given by her family to an individual to officially be married so long as she consents once she becomes an adult, this could be cancelled via a divorce document. But if the girl was mentally incompetent, she cannot do this, which is if she cannot tell the difference between her divorce document and another object. Generally, a child who has the mental competency to pick a stone over a nut is considered to be competent enough to legally acquire objects, and a child who is competent enough to borrow an object and return it when asked, he can legally acquire objects on behalf of others. Others say both of these statuses can only acquire for themselves, and it's additionally debated. There's further discussion, and it clarifies some laws of marriage. The minimum age for marriage is adulthood. There was that unique case mentioned where an orphan minor girl can be legally given by her family to an individual to be kept in his care until she becomes an adult, at which point they're properly married if she consents through miyun. The initial age of the situation, way prior to the actual marriage, is where she's mentally competent enough to tell the difference between a stone and nut. Children who are competent enough to buy and sell movable items, if their father contracted them to eventually marry a certain individual, they're allowed to receive their own divorce document in the year prior to adulthood, when they're legally allowed to take vows or consecrate items. They're legally allowed to reject a levirate marriage through the process of chalitza, and all actual proper marriages only become legal once both parties are adults. Additionally, an orphan can only sell his father's property once he's 20. New Mishnah. If a minor girl, in the above situation, waiting for adulthood to have her agreed upon marriage go through, she has to accept a divorce document herself, as she can't legally appoint an agent, so the husband can cancel the document until it reaches her. The father can appoint an agent to get and accept the document, so the husband can't retract it once it reaches the agent. Although this isn't really practically relevant, as it says in a later tractate, Condition 41a, that a father shouldn't betroth his daughter while she's a minor ever. Another rule, if the husband told the agent to give the divorce document in a specific location and the agent gives it to her somewhere else, it's not valid. If the husband just told the agent the woman's location, he can give it to her wherever he wants. If the woman told her agent to only accept the divorce document in a specific location and the agent gets it somewhere else, it debates if this is valid. If she told the agent to bring the document to her from a specific location and he brings it from a different location, it's valid. The Gemara explains the opinion, which says a divorced wife can't clarify where she wants her divorce to be accepted, unlike by the husband, is as the woman can be divorced involuntarily, as she's just informing the agent as to the location of the husband. New Mishnah. If a Kohen's wife told an agent to bring her divorce document, she can eat truma until she gets it. If she told the agent to accept it for her, she can't eat truma immediately. If she told the agent to accept the document for her but in a specific location, she can eat truma until the document reaches that location, and others say she can't eat it immediately. The Gemara clarifies the later case to be where she told the agent where the husband was, but that it would be activated once the agents reached a designated location. Additionally, the opinion which held the woman can't eat truma immediately after sending her agent would apply even if she told the agent to go east and she sees the agent heading west, as there's a possible concern that the husband bumped into the agent in that area immediately anyways, so she can't eat truma immediately. It explains how similar opinions exist by the laws of the Eruv boundary. New Mishnah. If a woman told people to write a divorce document and give it to his wife wife, or to divorce her, or to write a letter and give it to her, they can validly write and give a divorce document to his wife. If he told them to release her, or to provide for her, or to do for her as is customary, or to do for her as is fitting, he's not considered to have said anything, and they don't write a divorce document. The Gemara clarifies additional wording along these lines as to what is and is not considered to be a valid request to have a divorce document written and given. New Mishnah. If somebody was going out to be executed and he tells people to write a divorce document on his behalf for his wife, they may do so. Later, they also permitted people going to travel by sea or in a caravan to travel to a desert to do this, and some also added a dangerously sick individual can do this. The Gemara says an incident where somebody going to be executed said that some of his finances should be given as a gift to a sage, so it debates if the laws of a divorce document are similar to a gift by these laws. This case is unique, as it was a clear instruction as he was about to die, unlike by a very sick individual who can only give away parts of their property via oral transfer through an act of acquisition. It was debated, however, in this particular case, as the man used a very odd expression, saying to take 400 zuz from his wine, but it was explained and ruled to mean that he was strengthening his pledge to have them even take the money from the value of his wine if necessary. New Mishnah. If somebody was thrown into a pit and he said, whoever hears his voice should write a divorce document for my wife, they can write a divorce document based on this. The Gemara clarifies due to the issue of demons taking the forms of humans and tricking people, this case must be where they at least saw the man's shadow of a shadow, which a demon cannot mimic. Additionally, it's considered to be a time of danger, so you can write it even if you can't precisely identify who this is. New Mishnah. If a healthy man told people to write a divorce document for his wife, but he meant to annoy her, and then he fell off a roof and died, it was ruled if he intentionally fell off the roof, this is a valid divorce document. If it was accidental, like the wind blew him off, it's ruled to be invalid. The Gemara clarifies this case, saying it meant the conclusion of the incident clarifies the husband's intent. A related incident, a man entered a synagogue, saw a teacher, his son, and another man, said, two of you should write a divorce document for my wife, and then the teacher died. It was ruled that as people would appoint a son as an agent for this in front of the father, so the son would be allowed to do so with the third guy. New Mishnah. If somebody told 2 or 3 people to write and give a divorce document to my wife, they can do it themselves. If he told 3 to give a divorce document to his wife, they can have others write, sign, and deliver it, as he's considered to have designated them as a court. It cites a source for this, and others disagree, saying those men specifically must take care of it themselves. And also, if he told 10 people to write and give a divorce document to his wife, one of them can write it and 2 can sign it. If he said all of you write, 1 writes it and all of them sign it. So if even one of them died, the document would then be nullified. The Gemara debated the validity of if a husband telling 2 people to write and deliver a divorce document and they had a scribe write it, but they signed it, if this is valid. Some held that they should separate, but it should be further studied. It questions exactly as to what they were unsure about in this ruling, and it discusses a few potential issues. The opposing opinions on this are additionally explained. Further, if a husband told 2 men to ask a scribe to write it and 2 others to sign it, it's valid, but this should not be done, as the wife might have hired those witnesses and it would result in a false statement. If the husband wanted those 2 original witnesses to sign it in such a case, it's agreed it's valid, but it's now debated if it should be done between a large number of different opinions. Regarding the case of a large group of people, there's a debate if 2 or all must sign, but that's explained that one is talking about where he's enumerating everybody in the group, and the other one was talking about where he only enumerated some of them. It was enacted if a husband told a large group that all of you should write a divorce document, the scribe should clarify within the document that the husband said to write and deliver the document through any one of you, and it should be signed by any 2 of you. And that's the end of chapter 6. Chapter 7 of Tractate Gittin continues discussing the laws of the divorce document, and additionally it covers many related discussions on illnesses, cures, and similar. The first Mishnah says, if somebody contracts cardiacus, a delirium caused by drinking a lot of fresh wine, which some explain to be the name of a demon that causes this phenomenon, and then says that somebody should write a divorce document for his wife, it's not valid. If he said to write a divorce document, then drank wine and contracted this cardiacus, and said to not write the divorce document, we ignore him. If somebody became mute and he's asked if they should write a divorce document for him and he nods yes, he's tested 3 times to make sure he's communicating properly, and then they write it. The Gemara defines cardiacus as the demon which causes delirium from drinking fresh wine, and the name is relevant if you plan on writing a amulet of protection. It additionally lists ancient medicinal cures for this, and for heat stroke, which is water, and then for 2 days of heat stroke it's bloodletting, and then other ancient medical practices and whatnot for more, along with particular foods which cure frostbite. It also mentions some incidents where some servants of the sage of the Reish Galusa tried to kill the sage Rav Sheshas after he exposed that they were feeding people non-kosher food, first by putting a bone in his food, which he found, and then digging a hole and putting a mat over it, as Rav Sheshas was blind and he would walk over it and die. So he was warned right beforehand as he asked a nearby boy to recite a verse, and the boy said, "Turn to your right or to your left," and he avoided the trap. Another topic, there's the verse as said by King Shlomo, King Solomon, "I provided myself with masculine and feminine orchestration with delights of mankind, and Shida and Shidois." Some translated those last two as male or female demons. Some said it meant chariots. The reason King Shlomo needed demons was, as famously, he wanted to build the first temple in Jerusalem, but it was forbidden to build it out of metal tools, which made cutting stone pretty difficult, and he was told to use the shamir worm, a special worm that can cut stones it's placed on, which Moshe had used to engrave the stones of the ephod. He didn't know where the worm was, though, so he took a male and female demon and pressured them to tell him, but they said that only Ashmedai, the king of the demons, knows where it is. By the way, some write that Ashmedai is a title for king. It's not his actual name. Anyways, they told him Ashmedai could be found on a particular mountain where he had a pit dug filled with water, which was covered with a stone and sealed with his signet, and every day Ashmedai would ascend to heaven to learn Torah in the Heavenly Academy, and then come down to earth to learn down here, and then he goes to his pit, checks the seal, drinks some water, and then leaves. So King Shlomo sent his commander, Benaiah, son of Yehoiada, who took a chain with God's name engraved on it, wool, and wineskins, and then went to Ashmedai's lair. He dug from beneath the pit, funneled out all of the water, and then funneled in the wine, and plugged it with the wool, leaving the seal untampered, and hid in a tree to wait. Ashmedai returned, uncovered his hole, saw the wine, and he didn't want to drink it, as verses discouraged drinking wine, but eventually he became thirsty enough that he drank it anyways, he became intoxicated, and fell asleep. Benaiah then jumped down and wrapped him up in the chains, and when Ashmedai woke up, he couldn't break them as God's name was carved into them. So then Benaiah traveled with Ashmedai back to Jerusalem. Along the way, Ashmedai kept knocking down houses and trees, until a widow begged him to not knock down her house, so Ashmedai jumped so hard out of the way that he broke a bone. Ashmedai mentioned the verse, and a soft expression can break a bone. Anyways, Ashmedai saw a lost blind man and helped him on his way. He saw a drunk man and helped him on his way. He saw a joyous wedding and began to cry, and he saw a man asking a shoemaker for shoes which would last 7 years, and he laughed. He also saw a sorcerer doing sorcery, and this also made him laugh. Eventually he was brought before King Shlomo. Ashmedai informed him that when Shlomo dies, all he'll have is the cubits of his burial plot, in spite of him conquering the entire world and capturing him, and King Shlomo told him to tell him the location of the Shamir worm so that way he could build the temple. Ashmedai informed him that the worm was in the care of the angel, the master of the sea, which lent the worm to a certain bird so it could build its nests. Anyways, Shlomo sent others to find this bird. They did. They put a glass box over its nest. The bird returned, saw the box, flew off, grabbed the Shamir worm, and placed it on the box, causing it to split in two. So they scared off the bird, grabbed the Shamir worm, and brought it to King Shlomo. In the meanwhile, the bird swallowed a rock to choke itself for breaking its oath to the Master of the Sea. So the first temple of Jerusalem was thereby built. Anyways, Benaiah went to Ashmedai and asked him about all the things that had occurred while they traveled together. He was told he'd helped the blind man, as he knew he was totally righteous, and whoever helped him would be rewarded. He had helped the drunk man, as he knew the individual was wicked, and he wanted to use up any of the man's potential reward. He had cried over the wedding, as he knew the husband would die in 30 days, and the bride would have to wait 13 years to do Yibum, the levirate marriage, to remarry his brother, who was a minor at the time, until he became an adult. He'd laughed at the man who asked a shoemaker to make him shoes that would last 7 years, as he was going to die in 7 days, and he laughed at the sorcerer, as he didn't realize that there was a king's treasury buried directly beneath him. Anyways, Ashmedai remained with King Shlomo until they completed the building of the temple. Once Shlomo approached him and they conversed, Shlomo asked him about the verse that references demons being superior to humans. Ashmedai said he'd need to take off the chains and Shlomo's ring, which had God's name carved into it, to be able to show him, so King Shlomo complied with this. Ashmedai immediately swallowed the ring and regained his power, placing one wing in heaven and one in earth, and throwing Shlomo a distance of 400 parseos. Shlomo eventually recovered and spent a long while journeying back to Israel. Nobody believed that he was the king along the way. Eventually he made his way back to Jerusalem and claimed that he was the King Shlomo, but they said that's not possible, as the king's been sitting on the throne this whole time. Shlomo managed to convince them of his legitimacy, and he confirmed that the impostor Shlomo had never shown his feet, as demons have rooster feet, and additionally that the impostor Shlomo was trying to engage in intimacy with people forbidden to him. Anyways, Shlomo was given the ring and the chain, marched into the throne room, and Ashmedai flew off, but nevertheless, Shlomo lived the rest of his life in fear of Ashmedai, as the verse says, "Behold, Solomon's bed, 60 mighty warriors of the mightiest of Israel encircle it, all handle the sword and are skilled in warfare. Each man has a sword at his thigh because of terrors in the night. It's debated if Shlomo ever fully regained his status as king. It additionally gives some unique ancient medicinal practices and customs to cure types of headaches. There are cures for eye issues, types of blindness, nosebleeds, mouth bleeding, toothaches, heart conditions, intestinal pains, and others, types of leaves, types of foods or fluids or animals or customs and whatnot that are described. It has more of these for abdominal issues, fevers, and others. There are additional of these along with a number of general health advice. Back to the divorce document delivery. If the husband said to give the divorce document, then contracted cardiacus, becoming temporarily mentally incompetent, and during this said to not give the divorce document, it's debated if during this state they can give it anyways, or if they should just wait until afterwards. The debate is based on if this state is compared to the man being asleep, or if it's compared to the man being insane. Additionally, unlike by an insane person, this illness can actually be cured as described earlier. We try to dispute the opinions that say you can't bring a document in such a state, as this opinion held elsewhere that if somebody's throat was cut through both pipes, the trachea and esophagus, and he motioned to have his divorce document written, he is believed and it's written. However, this is different than cardiacus, as there his mind is compromised, unlike here where he is not strictly unable to think clearly. During such a state with his throat cut, you can have the divorce document brought, and you can also testify that he died from just seeing this, as he's definitely going to die. There are additional points on this. In regards to questioning somebody who became mute, there's a concern that he just has an illness where he just repeatedly nods, so it's explained that he asked a question that should be answered no, then one that should be answered yes, then no, etc. It gives other additional methods. It additionally debates the levels of mental competency attributed to an ordinary mute or a deaf mute, which is typically stricter. There are additional points on this. From a different discussion that's more in Tractate Gittin, it mentions that a deaf mute brother can't divorce from the levirate marriage if his brother was mentally competent, but if the mentally competent brother did the levirate marriage with his mentally incompetent brother's wife, he can validly divorce her. Others did dispute this and would additionally hold that an insane woman can never be divorced out of concern that people will try to be immoral with her afterwards. New Mishnah, if somebody went to a man and asked if they should write a divorce document for his wife, and the man said to write it, and they have a scribe write it and other witnesses sign it, even if the husband gives it, it's not valid, as the husband needs to tell the scribe to write it and to tell the witnesses to sign it. The Gemara says the issue is that the husband said they should write the document. If he said to give it, it would have been valid, according to the opinion that words can be transferred to an agent. The ending of the Mishnah then would either be according to the opposing opinion, or alternatively the whole Mishnah is like the opposing opinion and the ending bit is just where he said to give the document. Some would hold in the described case, the scribe is allowed to be one of the signers, and this could be problematic as the scribe could end up signing the document when he wasn't requested to, so it additionally debates who this Mishnah goes in accordance with. New Mishnah, if a husband told his wife, this is your divorce document if I die, or this is your divorce document after this illness that he has, it's invalid, and it's like he said nothing. If he said, this is your divorce document from today if I die, or from now if I die, this is valid. If he said it's from today and after death, its validity is in doubt. So if he dies, she must do chalitza and can't do yibum. If he said this is your divorce document from today if I die from this illness, and he got better and was walking around the market, and then he got sick again and died, he's checked. If it was from the first illness, she's divorced, and if not, they're not divorced. The Gemara explains the term if I die can either mean from now, as in this point here, or it can refer to after he dies at a future point. If he said from today if I die, that's the first instance. It's retroactive from that point. If he didn't say from today, it refers to after his actual death. It debates the validity of the remaining terminology. Essentially, if the husband said he wanted the document to take effect after he died, it's debated if this should take effect literally after he dies, or if it means it should apply retroactively in the event that he later dies. It's disputed between a few opinions as to who we hold like. In regards to where the document being given is reliant on him dying of the illness and he recovered in between before dying later, it said it's similar to a gift, where if somebody offers one while sick and then gets better, we assume he retracted it and it would be nullified. Others debate this comparison. Based on the discussion, it's held if a person has an illness, offers a gift, and then transfers to a second illness and dies, his gift transfer would remain in effect. Additionally, others dispute the opinion that if somebody sick offers a divorce document and then recovers, it's nullified. They would instead hold the document ends the marriage, so people won't come to think the document can take effect after the husband's death. This can technically exist, as has been described. The whole betrothal to begin with is verified rabbinically, so it can therefore be retroactively undone rabbinically through whatever means. It cites related incidents by monetary laws to whether people can be held responsible for unusually occurring accidents. New Mishnah, if the husband gave a divorce document to take effect retroactively when he dies, she should no longer be alone with him unless there are witnesses even a slave, unless it's her female slave who she's on familiar terms with. Additionally, it's debated as to what her marital status is. Some say it applies, others say it's in doubt. The Gemara says, in such a situation, if the witnesses saw them cohabit, he can assume it was done with intent to remarry, but if he saw him pay her after, we assume it was done impermissibly. Others say that even if he paid her, we assume it was to marry and the money was just a gift or something. Others disagree with this whole explanation and instead simply say if they're seen cohabiting, it's a dispute if they're assumed to be doing this to remarry or not. This is additionally qualified. In regards to if they're considered to be married, it debates if the husband is responsible during this period to provide for her. New Mishnah. If a husband told his wife that she's divorced on condition she gives him a sum of money, she's divorced, and she must give the sum. If he said it has to be given from now until 30 days, she's divorced only if she gave it within 30 days. There's a recorded incident where a husband had made the divorce conditional on the return of his cloak, and she had lost the cloak, so it was ruled that she could have just given the value of the cloak instead. The Gemara debates based on the particular wording if the document still needs to exist when she gives the money, which is additionally debated elsewhere by the laws of betrothal. It repeats both, as there's a difference between divorce and betrothal as to the willingness of the husband to make such a conditional request. It additionally debates these opinions. This is further discussed. It also clarifies the point on the payment within a time frame to say that this is an actual part of the conditional requirement, not just a request to have her pay it faster. Further, the broad case with the cloak is to establish that the value of an object can be given in such a described situation. There are additional points, and it brings a case where the custom in a region was for a sharecropper to water crops 3 times a year and take a fourth of the produce, and the deal was made to water 4 times per year and take a third, but it rained, so he only ended up watering 3 times, and it was debated if he'd still get the full produce payment. This is said to make the sharecroppers entitled to the extra portion, as it's comparable to the case of the value of the cloak being repaid instead of the actual cloak itself. It goes through some related monetary principles and additional instances of a conditional divorce document. These are further qualified. New Mishnah. If a husband told his wife that this is a divorce document on condition that you serve his father or nurse his son, she's then obligated to nurse for 2 years, although some say 18 months. If the father or son died before that, the divorce document is still valid. If the husband said the document is conditional on you serving my father or nursing my son for 2 years, and the son died or the father refused her service, not out of anger, it's not a valid divorce. Others disagree and say it is, and would hold that so long as the wife didn't cause the condition to be unable to be fulfilled, the divorce would still go through. The Gemara explains that some others would actually require her to only nurse or serve for a single day, although that could possibly be an instance where the husband had specified that it should be for a single day, and others disagree, and it's debated. There's further discussion on this. New Mishnah. If a husband told his wife, this is your divorce document, if I do not return within 30 days, and he traveled from Judea to Galilee, reached Antipras, and returned, it's nullified. If he traveled from Galilee to Judea, and he reached Kefar Osnai, it's nullified. If he was traveling abroad, and he reached Akko, and then returned on time, it's nullified. If the condition was that the divorce takes place if he's absent for 30 days and he was going back and forth, it's still a valid divorce as he wasn't alone with her during this period. The Gemara explains the particularly mentioned regions is it's where he said that's where he's going, which is conditional for the document to take effect along with him returning within 30 days. The remaining points are qualified. New Mishnah. If a man gave a divorce document on condition that he doesn't return within 12 months and he died during that period, it's not a valid divorce document. If he said this is your divorce document from now, if I don't come back within 12 months and he died during that period, it would be a valid divorce document. If he said if I don't return within 12 months, write a divorce document for my wife, or write a divorce document if I don't return within 12 months, and they wrote it during 12 months and gave it after, it's invalid. Others say by the second instance it would be valid. If it was written and given after 12 months, but the husband had died, if it was given after he died, it's not valid. If they're not sure if it was before or after, her marital status is in doubt. The Gemara additionally qualifies these points with particular discussion on the differing opinions along with some particular date stipulations. And that's the end of chapter 7. Chapter 8 of Tractate Gittin covers some additional further laws of divorce and the delivery of the divorce document. The first Mishnah says, if a man throws a divorce document at his wife in her house or courtyard, she's divorced, as it's in her property. If he threw it into his own property while she's there, she's not divorced. If he threw it into her lap or sewing basket, she is divorced. The Gemara cites verses which source these laws of particular domains. Additionally, in regards to putting the document in her property, this is where the husband doesn't share it, as he had relinquished his rights to the property. Typically, such relinquishment of property is not allowed, so this must be where it was done during the initial stage of marriage or similar. Additionally, some add that there is no issue of this whatsoever, as technically they're married, so her hand would also be shared in ownership by the husband, which would be equally problematic. Therefore, this opinion would say that the divorce document and her independent ownerships occurs simultaneously. This is additionally qualified. It cites some particular incidents of these laws occurring. In regards to him tossing the document into her property, some clarify this to mean she actually must be there, at least beside her house or courtyard. Others say that she can be far away, and the dispute is like if her courtyard or house have a category of her hand or of her agent. Others say both agree it has the status of her hand, but they disagree if she needs to physically be there, attached to it, for it to be valid. There are related incidents mentioned. Additionally, in the husband's house, if the woman owns a bed inside, he can validly put the document on her bed. The particularities of this are discussed. In regards to tossing it into her sewing basket, some require it to be hanging off her, and similar. This would also apply to things similar to a sewing basket. New Mishnah. If the husband hands his wife a divorce document and says, "This is a note of indebtedness," or if the wife just finds the divorce document lying around by him, it's not valid. The document must specify that it's given as a divorce document. Similarly, if he hands it to her while she was sleeping, it's not valid until he says that he's given her a divorce document. The Gemara suggests a clarification where she grabbed the document that was by him as to be where it was on his person, and he turned to her, essentially handing it towards her, and she took it from him. It brings sources for the validity of this logic. Also, if a man wrote a divorce document and gave it to his wife's slave who was sleeping while she guards him, it's valid. But not if he's awake, as then he's legally regarded in a similar status as a courtyard that's not under her control. Where it does work is clarified to be where he's bound, so he's classified similar to a stationary courtyard, which can acquire a divorce document for its owner. New Mishnah. If a woman was in a public domain and the husband throws the divorce document at her, if it's near her, she's divorced. If it's near him, she's not. And if it's right in the middle, she has a doubtful status. This would also apply by marriage and with debt, by tossing the money towards the individual, if he acquires it or not. And if it's right in the middle, they split it. The Gemara defines these amounts as being within 4 cubits of either of them, and where it's half and half is where there's 8 cubits between them, and the document extends into both of their 4 cubits. Some say it just means that whoever is closer. Some say it goes by who's able to guard it, and if both or neither can, it's half and half. There are additional points and points on these principles by marriage. An additional rule: if a husband hands his wife a divorce document, but there's a string attached in his hand, if it's strong enough that he could pull it back to himself without breaking the string, she's not legally considered to have been divorced, as he still partially controls the divorce document. Additionally, if her hand was open and positioned downwards and he threw it into her hand and it falls out, she's not divorced. If it then is destroyed before it hits the ground because there's a stream beneath her. New Mishnah. If the wife is on her roof and he's in his courtyard and he throws the divorce document up to her, she's divorced once it enters the airspace of her roof. If he was on his roof and she was in her courtyard and he threw it down to her, she's divorced once it leaves the roof's domain, even if it's destroyed before it hits the courtyard. The Gemara explains by the wife's roof, the roof is guarded, either as there's a fence around it or it's within 3 handbreadths, so it's considered to be a part of the roof, as it's within its airspace. By her courtyard, it's considered to be guarded, as the courtyard walls here extend above the roof. The remaining points are additionally qualified. It also describes some points as to how these laws differ from those of the Shabbos domains. Further, if there's a double courtyard, one inside another, with the inner one belonging to the wife and the outer one to the husband, and the outer walls are higher than the inner walls, and the husband tosses her divorce document to her, as the outer walls guard the inner walls, once the document reaches the airspace of the outer walls, she's divorced. This is additionally qualified. New Mishnah. There's a dispute if a man can divorce his wife with an old divorce document. An old divorce document is if the husband secluded himself with her after he wrote the document, but before he gave it to her. The Gemara says this dispute between Beis Hillel and Beis Shammai is on whether we're concerned the divorce will precede the conception of a child. Nevertheless, some hold that if the woman was given an old divorce document and remarried, she can stay remarried, and some allowed the remarriage to begin with anyways. New Mishnah. If somebody was in Babylonia and they wrote the date of the divorce document according to the reign of the Roman Empire, here referred to as the unworthy kingdom, or according to the kingdom of Media or Greece, or since the construction or destruction of the temple, or if he wrote it in the east and wrote it that it was in the west, or vice versa. If the woman had remarried on the basis of such a document, she must leave both her prior husband and her new husband and receive a divorce document from both, and does not pay her marriage contract or any of the forms of sustenance from either, and if she took sustenance from either, she must return it, and any new children born to her are considered to be illegitimate, a mamzer. If the husbands were kohanim, neither can become impure to bury her if she dies. Neither husband is permitted to her findings or earnings property. Neither can revoke her vows, and if she was not a Kohen, she can no longer marry one. If she was a Levi, she can no longer eat Meiser. If she was a Kohen, she can no longer eat Teruma. Neither heirs from either inherit her marriage contract, and each of her brother-in-laws will do Chalitza and cannot do Yibam. Similarly, all of this would apply if the scribe wrote either of their names or cities wrong. Additionally, this list of penalties apply if there was a woman whose brother-in-law passed, but they were one of the mentioned relatives, so they don't do Yibam or Chalitza, so her co-wife went and remarried without needing to do Chalitza, but they then found out the widow was an Ilonis, so their co-wife needed to have done Yibam or Chalitza, so their new marriage is void, and as mentioned, the listed penalties apply. Additionally, this would all apply if the widow married the brother-in-law through Yibum and the co-wife married someone else and then found out that the widow was an Ilonis. In an additional case, if the scribe accidentally gave the divorce document to the wife and the receipt to the husband, which they then exchange, so they now both have the wrong document, and they found out what happened later on, all of the above penalties apply. Others say if they found out what happened immediately, there's no divorce, but if they found out later, the divorce is valid because the original husband shouldn't be able to invalidate the marriage of the second. The Gemara clarifies the unworthy kingdom, as mentioned, refers to the Roman Empire, and they're called this because they didn't develop their own language or alphabet. The dates of the local monarchy are used in divorce documents so as to have peaceful relations with the monarchy. The remaining points are additionally clarified. This goes further and it also defines what classifies as immediately after the divorce or a while after, along with the remaining points. New Mishnah: if the husband wrote a divorce document for his wife but then changed his mind, Beis Shammai says he's disqualified her from marrying a Kohen. Beis Hillel says she's not disqualified even if he actually gave her the document, but conditionally, and the condition wasn't yet fulfilled. The Gemara cites some related incidents along with some points on tithes to show the descent of the greatness of later generations. New Mishnah: if a man divorces his wife and then stays in an inn with her, Beis Shammai says they don't need a second divorce document. Beis Hillel says they do if they divorced from the final stage of marriage. If it was from the earlier stage of marriage, they wouldn't be so comfortable and they wouldn't require a second divorce. The Gemara says some hold this dispute is where the witnesses actually saw them cohabit, and the debate is if this act was to remarry or if it was just done impermissibly. It debates this from other sources. Others say it's where the witnesses saw them seclude as to if this creates a presumption of cohabitation. The remaining points are qualified. New Mishnah: a divorce document is written and signed very uniquely. A few lines are written, it's folded over and sewn shut, and the outside is signed by a witness. Then further is written, it's folded, sewn, and signed on the outside, etc. It needs 3 folds and 3 signatures. If one of such signatures is missing, the husband must divorce her new husband, and all of the earlier mentioned penalties apply. Some say anybody can sign the extra fold to fix it. Others say nobody disqualified except for relatives. This invalidation applies so long as there are more folds than witnesses' signatures. The Gemara says these issues apply in case the husband said all of you signed the document. It further explains the debate as to who can make the additional necessary signatures, and some say it doesn't apply if there is or are more than 4 folds and 3 signatures, in which case they would agree that disqualified witnesses, besides for relatives, cannot sign it. The remaining points are additionally qualified. There are additional points, and some even allowed a random slave from the street to sign this document to fix it. And that's the end of Chapter 8. Chapter 9, the final chapter of Tractate Gittin, goes through some additional final laws of the divorce document. The first Mishnah says, if a husband divorces his wife and informs her that there's a stipulation that she can marry whoever she wants besides for one particular individual, some say she can marry anyone besides for that one guy, others say she can't marry anybody, so the husband should instead retract the divorce document and give it back, now saying that she's allowed to marry anybody. If the restriction was written into the actual divorce document, even if he erased it later, the document is invalid. The Gemara explains the Mishnah used some odd wording of that she can marry anyone but a specific individual. It debates if this means except for him or on condition that she doesn't marry him. Based on a related discussion of tsaras, leprosy, impurity, where it uses similar wording, it shows that it means except for this person. Others do still disagree. It further explains this debate as to whether specific qualifications within a divorce document is valid or not. It also debates if this concept is permissible by betrothal. There is an additional unresolved point as to what if the husband had told the woman she can remarry anybody besides for some particular people, and then handed her the divorce document saying she's allowed to marry those people. It's debated if she can now marry anybody or if he meant she can now only marry those particular individuals. In regards to the opinion that the husband can make restrictions within the divorce as mentioned later, many sages wanted to refute this, so they posited many potential issues that could arise in this situation, but it was said it couldn't be refuted. It gives additional instances of this concept. The attempted refutations are additionally discussed. Further, any potential condition on a divorce cannot prevent complete marital severance. For instance, if the document is conditional that she no longer drinks wine, it's valid. If it's conditional that she no longer drinks wine so long as the wife is still alive, it's invalid. If it's conditional that she no longer drinks wine as long as another particular person is still alive, this is valid. Additionally, it's debated as for what to do if the man gave his wife a divorce document saying, you are not my wife today, but you are tomorrow. It said once she's divorced for that first day, she's permanently divorced. If the husband told his wife she's divorced on condition she goes and marries a certain person, it said she cannot now marry that person, so that way people don't think that you're allowed to trade your wife as a gift. But if she did end up marrying him, they don't need to divorce due to this rabbinic issue. Others disagree and say she actually can't marry anybody, as she has to marry him as stipulated, but she also can't marry him due to the mentioned issue. So he would hold that she must divorce anybody she marries, besides for the particular individual as was stipulated. If there is an impossible to fulfill condition in the divorce document, like that she flies up to the sky or something similar, it's debated if it's valid. We hold it is. It's debated if the condition that she does something impermissible, like eat a pig, if that's similar to this, or as it's a physically possible thing, if it's considered to be a binding condition. If for the debated validity of such a stipulation, the remaining points from the Mishnah are additionally qualified. These are discussed further along with some particular incidents. New Mishnah. If a husband gives a woman a divorce document on condition that she doesn't marry somebody that she can't marry anyways, such as his father, her brother, a non-Jewish person, or otherwise, it's a valid divorce. If she was a widow and he said she can marry anybody besides for a Kohen Gadol, or now that she's a divorcee, a Kohen, or an illegitimate individual, or anybody else that you are permitted to make a betrothal with, albeit through a transgression, the divorce is invalid. The Gemara clarifies what additional cases these parameters include. If the husband stipulated that his wife can marry anybody besides for a particular minor, it's debated if this is a valid stipulation, as a minor is not allowed to be betrothed until he's an adult, or perhaps it would be valid as he'll become an adult eventually, undoing that factor. It debates this from a few similar cases. This first point, it said the divorce is invalid, and the remaining points are unresolved. New Mishnah. The main part of the text of the divorce document is, "You are hereby permitted to any man." Some add that the document must have the words, "And this is what shall be to you from me, a document of banishment, and a letter of abandonment, and a bill of release, to go and wed any man that you will want." The main parts of an emancipation document are the words, "You are hereby a free woman or man," or "You are hereby unto yourself." The Gemara discusses other particular phraseology that could function within these documents. It also explains particularities in regards to the method of writing the divorce document, the way certain letters should be marked, spacings between certain letters and words, and similar. There are additional points on this. It generally looks like this. New Mishnah. 3 types of divorce documents are invalid, but if the woman remarries after receiving one, her children are still legitimate. A document written in the handwriting of her husband, but wasn't signed by witnesses. A document that was signed by witnesses but has no date. A document with a date, but only one signed witness. Some say if it wasn't signed by witnesses, but it was given before witnesses, it's valid. And also an unsigned document given before witnesses can be used to collect encumbered properties, as this opinion holds witnesses' signatures aren't essential, they're just to prevent issues. The Gemara says this is unlike an old divorce document, as described earlier, where the remarriage is permitted initially, unlike here. It also doesn't discuss an unsigned folded divorce document, also mentioned earlier, although it's similar. It also explains why it didn't bring the mentioned case of the document being dated, unlike the region. This is further qualified. There are additional points on this and several opinions as to who exactly we follow by these laws. New Mishnah. If 2 men sent 2 identical divorce documents to their wives through an agent and they got mixed up, both documents should be given to both women. So if one got lost, the other can't be used. If 5 men all write within the same divorce document that they're divorcing their wives, with all the signatures below, it's valid and should be given to each of their wives. If a separate basic formatting was written for each of them, with the witnesses signed at the bottom, only the bottom one is valid. The Gemara additionally qualifies specifics on these points. New Mishnah. If there were 2 divorce documents written on one paper beside each other, and there are 2 Hebrew witnesses from one going beneath both, and 2 Greek witnesses from the other extending beneath both, only the first Hebrew document is valid. If one is Hebrew and Greek, and one is Hebrew and Greek extending beneath both, then both are invalid. The Gemara explains the particular issues with these cases in regards to the specific formatting of the signatures on a divorce document. These are discussed further. New Mishnah. If the remainder of a divorce document is written in a second column with the signatures beneath that one, it's valid. If the signatures are at the top, to the side, or on the back of an unsealed divorce document, it's invalid. If 2 divorce documents are attached vertically by the tops and the signatures are in between, both are invalid. If both are attached by the bottoms with the signatures in between, only the document facing the same way as the signatures is valid. If the bottom of the first is attached to the top of the other with the witnesses between, only the top document is valid. If a regular document writing was in Hebrew and it was signed in Greek, or written in Greek and signed in Hebrew, or one witness's signature was Hebrew and the other was Greek, or it was written by a scribe and signed by one witness, it's valid. If the witness signed name witness, it's valid. If he signed the son of his parents' name witness, that's valid. If he wrote name the son of his parents' name, but he didn't write witness, it's valid. And this was how some particularly righteous individuals would sign their documents. Additionally, if in the actual document the husband and wife's last names were written instead of the parents' names, it's still valid. The Gemara discusses the issues in regards to the formatting with illicit cases. It debates the specifics as to what's being referenced in the described cases, with the witnesses being signed in between, along with a few particular incidents, and it also expounds on a number of related verses. New Mishnah. Only a Jewish court is allowed to force a man to give a divorce document. You're allowed to hire non-Jewish people to beat up the husband until he's willing to give the divorce document. The Gemara further discusses this, along with the validity of certain courts from those times doing this. New Mishnah. If a woman was rumored to be betrothed, she's treated like she's betrothed. If a woman is rumored to be divorced, she's treated like she's divorced. There are mitigating factors which remove the effects of such a rumor, such as if the woman was divorced conditionally, or if the betrothal was thrown to the woman, so it's questionable. The Gemara discusses this along with the believability of other types of rumors of impermissible relations, particular variants of betrothal, like in a different town, and similar. These are additionally discussed along with particular incidents. These are all further discussed. New Mishnah. Beis Shammai says, a man is not allowed to divorce his wife unless he found her being adulterous, which is based off of a verse. Beis Hillel says a man can even divorce his wife if she did something offensive to him, like burn his food. Rabbi Akiva said a man can even divorce his wife if he found someone he'd prefer to marry, which is also based on a verse. The Gemara additionally debates the wording of these verses as to their implication. Additionally, if a husband divorces his wife for no reason, he does not need to remarry her. It's also said to be improper to plan on divorcing a wife without letting them know. There are additional verses spoken on in regards to grounds for divorce on the topic of wives acting publicly improperly, and to be careful of such things. There's more on this, and it says that God despises a man who divorces his wife in regards to a second marriage. And further, it's said that when a man divorces his first wife, even the altar in the temple cries, which is based on a number of verses. And that's the end of chapter 9 and the entire Tractate Gittin. Alright, that was a lot of information. So here's a rough summary of a lot of the practical takeaways from this tractate. A man can divorce his wife through a divorce document called a get. There are particularities on the writing and signing of such a document. It must be done specifically with intent towards the divorced woman in question and signed and certified by witnesses. Generally, divorce is very much frowned upon and should only be done if absolutely necessary. The second temple was destroyed due to causeless hatred and will, God willing, be rebuilt through causeless love. And that's about everything. Thank you so much for watching.